Something memo for it.
Why second?
Either it was direct.
Give all the memos, please. Give
Maybe,
give all the
Maybe.
memos.
maybe permitted to mention.
To be dictated that order.
Yes, yes. Give. Madam, why you are mentioning, sir? I know, sir. Give us some kind of a gasping time, sir. Yeah.
Maybe please.
Cause of action is survive today or day after tomorrow.
Yep. Sir, write the urgency here. Yes.
May please your lordships, my lord, item 48 in your lordships list today.
Yes.
My lord, it is on the appointment of GST tribunal members headed by, my lord, a sitting judge of the Honorable Supreme Court, and the list is ready. All interviews are over, everything is ready. There is a direction by your lordships not to release the list, and my lord, for the past 2 weeks it is not released. Lord, we will, the writ petitioners, about writ petitioners, everything we have given it in the seal cover, and also counter affidavit is ready. Will your lordship be kind enough to take it at 2 p.m. today? My lord, take only 5 minutes.
Just let us see if we can. Definitely.
And for the petitioner,
Yeah.
Petitioners.
the matters was adjourned to tomorrow, 26th, my lord.
Okay. This matter is.
My lord, any time tomorrow, I'm
mentioned.
ready. Mr. Das is not available today. He's out of
Okay.
station.
Tomorrow is no problem. Tomorrow is fine.
Anytime.
Well, tomorrow is fine. Only request.
Tomorrow will take up.
Only request is, my lord.
Tomorrow, anytime.
So in the first half, let us see.
First hour. Excuse. Deeply obliged. Extremely obliged.
Yes, but. Yes, call the list.
Item number 1. Item number 1.
Personal directly in this item 1, whether the opposite party number 4 has submitted a bid accompanying the government work experience. Which the petitioner says that the opposite party not a annex in a single document towards the experience of any government organization as provided in the tender notice. And it was only for that purpose you also keep today.
I've got instruction and find the worker come up to my account. So, appearing for the OP number 4. So if they can serve me a copy of the writ petition, so it can be taken up on subject to lordship's convenience on 30th also. We can, in the meantime, I'll take instruction, whatever is there.
Come on 30th, serve the copy.
No, I heard that you also just say.
Vokalatama by your advocate and record.
Yes, that's all. We have 5.
The lawyers, they signed off the accept.
That is the practical, all the associates in the office also.
Whatever. Only one who accepts.
And
That's why I was asking how many advocates have signed. New practice, but unique practice.
no, normally it is nowhere done in India anywhere else except Orissa High Court,
I'm really surprised that a senior advocate has to sign.
file a memo of appearance.
No, I have never come across.
Nowhere, my lords. Not even in the tribunals or in any other authorities also, but somehow or the other this practice has been going
I
on.
do not know.
And bar is getting some funds and the welfare fund also. That,
I do not know because once you are designated as a senior advocate under the Advocates Act, you cannot plead, you
No.
cannot file vokalatnama, you cannot.
and that appearance is also for the day. It need not be also.
Absolutely. So I think what is the. And yes, Scotty.
Yes, I'll submit a lots of yesterday. Suppose he will not grant the entry model because there is a because of only private document he has, and but this is Kotak your lots of
And
Lordship
give
kept it
the
on,
entire
while
records
finally
and everything.
they will not be in.
The work order has not
Work order has been issued.
executed, started.
There already the
No, no.
manpower is there.
No, no, there is not, my lord. They have not. But there is, my state will say whether the work is started or not. Oh, what date they have. In the private experience, you also that for this reason, this was
Already issued much earlier than you moved the event.
Your Lordship, that's only query that whether he has submitted any.
Sorry, whatever
complaint.
will come later. Thank you.
Item number 2.
It's already.
Whether the materials were supplied or not. Not my instruction that was not supplied, but till date also the materials were not supplied. What will also be, I'm filing an affidavit, Miller. Kindly have a glance. On the last date of the supply, we received the letter from the opposite party number 3. Page number 8, you know. And it's your B by 4, page 8. We received the letter on the last date, that is 4/4/2024, stating that due to imposition of model code of conduct, you are hereby requested not to execute the supply of 3-tier vertical mile steel stand.
So the election was over within a month or two.
Then thereafter, we have made representation and requested them to allow us to supply your Lordship. May kindly see page 9, Lord, next page. Page 9. Page 9, we have addressed this letter to the managing director, to allow us to supply, but they did not give any instruction regarding supply. Then thereafter also, Lord, on 18/10/2024, we have made representation, Lord, but till date no reply was given to us.
Yes. Hello, company. Who is representing this company?
Representing the corporation, ma'am.
The Orissa Agro Industrial
Yes, yes, ma'am.
Corporation Limited.
I'm.
What are you doing?
My lord, what had happened is, after this, there was a application which was moved by the petitioner before this honorable court. And order number 3, Lordship may kindly see. That was on 30/5/2024.
Yes.
30/5/2024. There was an interim application which was filed by the lead petitioner with a prayer to direct the opposite party.
Says that no urgency really arises and no action. So is likely to be taken again. So there was no difficulty. But there was no restraint order. against you.
Since the matter was pending for adjudication, my lord.
You know the why there has been an amendment in 2022. That we are filing a litigation before the court does not mean that there should be stay of everything. That's why Arbitration and Conciliation Act Section 36 is amended. Why you will keep
Just such a kind of a submission was made by me, my lord, before the court. I advised that when the matter is going to be likely to be listed and disposed of, wait for
No,
that.
no, it's not the question because after all, the purpose for which the entire tender was floated, that if that gets frustrated.
But
And I am really unable to comprehend that maybe that code of conduct is imposed or has come. But it does not mean that the order which has already been issued, supply cannot be made. I am really surprised. Functioning cannot be kept at hold. It's only the new policies, the new decisions,
that cannot be.
execution that is somehow is been rendered. No, this is something that's to be understood. No, I understand. Yes.
Petitioner has absolutely no locus standi. Because, my lord, the petitioner himself had never executed any agreement at any point of time
I
as a
understand.
SSI unit. So they are not even, my lord, eligible.
No, I understand.
Therefore, yesterday, my lord, I humbly submitted that they are meddlesome interloper. They just want to, my lord, create some kind of a difficulty in execution of this project, my lord.
Subject to that submission, there was no publicity and this was a.
No, you have raised us various clauses of the tender documents. You are trying to impress upon us that whether this can be termed as a bid or a tender for procurement of the product, or it was an offer given to all the SSI units to get themselves impaneled.
Get impaneled.
Impaneled. That is what you
That is
really
what-
wanted to create this.
That is.
There is some kind of a gray area in this.
That is there.
But the bottom line of the entire story is that they perceive this as the tender for procurement of the goods. If the goods are supplied or if they want to purchase it, then in that event, you go and get yourself impaneled with them.
Well,
How difficult?
there is no
Impaneled with
difficulty.
them.
There was no difficulty in that, but
If
now
they
they are
make an
stopping at the
application,
door.
make a decision to impanel him,
Well-
if they fulfill all the conditions so that
Well,
in future they
In
can.
future, my lord, they can participate.
They can
participate in-
Well,
Where is the tender document?
in the
Page
document in
24, my lord.
annexure 3.
23, 24.
Annexure 3.
Page is, my lord, 24.
23.
Start
Starts
with
with 23.
Ah.
Then it is 24, 25. and- Yes.
The issue of petition is a request of a not impaneled inspection. The supply. Assuming the tender.
Which permits me to this one. I'm also assailing the fact that there was no sufficient publicity. There are judgments of our High Court that says that you have to give sufficient time and reasonable publicity.
Whatever.
For
Assuming the tender. Floated on 2nd March 2024. For supply of 3-tier vertical mild steel stands. By the Orissa Industrial Corporation Limited. Being arbitrary, illegal, and discriminatory in nature. it is a word in the Rectification that we said Orissa Agro Industry Corporation being a garment of Orissa undertaking was established to promote the agricultural products and the machineries, and also develop the biofertilizer, manure, cattle, and the poultry feeds with an avowed object of educating and training the farmers to optimum utilization of the technologies in the farming sector. It is further aware that the tender was floated on 2nd March 2024 for supply of the aforementioned material at different Anganwadi centers.
Floated at 10.
Just Anganwadi centers. Without making a wide publication, and also in haste. So it is stated that the meeting of the where is that 2nd March meeting?
24, page 21.
Page
21. At the top. Meeting held at 4 p.m.
stated that the meeting under the chairmanship of a director of the agriculture and the food production was held on the date when the said tender was floated at 4 p.m. And the resolution taken in the said meeting would indicate that that the aforementioned materials will be supplied at the Anganwadi centers as per the suggested specifications, and the procurement and supply will be ensured through the rate contract / short tender, short procurement from the government agencies as per the requirements. Senior counsel appearing for the petitioner submits that the moment the committee under the chair of the director of the agricultural and food production decided the procurement of the said goods at 4 p.m. It is inconceivable that the invitation, that publication inviting the invitation by way of a tender would be floated prior thereto. it is further contended that the various clauses appended to a tender is styled as an expression of interest or suggestive of the suggestive of the facts that the invitation was sought to impanel the suppliers to meet the requirements of the said corporation and cannot be construed by any stretch of imagination to be a tender for supply of the goods. It is further submitted that even if, for the sake of the argument is considered as a supply of the goods, there is a complete lack of synergy among the different clauses of the said tender. And its comprehension is vague and ambiguous. He thus submits that the petitioner, who has all expertise in supplying the goods, was prevented from participating in the tender. And therefore, the tender should be declared as illegal, arbitrary, and a smack of discrimination perpetrated upon him. The counsel for the opposite party number 1156, who was adjudged as the successful bidder, having quoted a competitive price for supply of the goods mentioned in the said tender document, submits that after the purchase order was issued by the corporation, because of the declaration of the assembly or parliamentary of the assembly election, the code of conduct becomes operative and a fetter was put in supplying the said goods, though the same is otherwise ready, and the said opposite party is facing inconvenience because of the aforesaid materials occupying a major portion of the storage available to them. So it is further submitted that the letter issued by the corporation is indicative of the fact that the supply was kept in abeyance because of the code of conduct becomes applicable, but after the same was lifted, yet till date no directions have been issued to supply the same materials. So he thus submits that the said opposite parties have incurred a huge expenditures in procurement of the materials, and the inaction on the part of the corporation has caused an immense loss. The corporation, the senior counsel appearing for the corporation submits that because of that the same tender was floated for supply of the materials as mentioned there. And a composite stipulation can be seen therefrom that they also intended to impanel other the small
Small scale industries.
small scale industries in order to expand the horizon of the competitions and the competitive rates to be quoted for supply of the materials in future. Stop. He vociferously submits that the language used in the tender document cannot create any confusion in the mind of the person that it was actually intended for impaneling the suppliers, but for supply of the materials, the specification thereof is given in lucid manner. He further submits that because of the code of conduct having imposed, because of the declaration of the assembly election, the supply could not be affected. Although the purchase order has already been issued in favor of the opposite party number 4 to 6. Obviously, the state who is arraigned as a party, state is a party, remains as a party, has a negligible role in the cause of action pleaded in the instant petition, and the counsel appearing there, appearing for them, have adopted the stand taken by the corporation, being a government of Odisha undertaking. It is no doubt true that the meeting of the committee, this resolution is at page 21.
Page 21.
The meeting of the committee under the chairmanship of the Director of the Agricultural and Food Production was held on 2nd March 2024 at 4 p.m. One of the agenda in the said meeting was for supply. The agenda was for supply of the 3-tier vertical stacks at respective Anganwadi centers. And the resolution would reveal that the procurement thereof was agreed either through a rate contract or short tender or procurement for the government agencies as per requirement. Obviously, the tender document annexed to the requisition could corroborate the fact that the said tender was floated on the same day for supply of the said material. After having approved by the competent authorities. inviting the applications between the period from 2/3/2024 to 11/3/2024. The expression of interest as the caption goes is for procurement of the 3-tier vertical mine steel stand for cultivation of the vegetable plants. And the date for and the last date for submission of the tender document was fixed on 11th March 2024. The bids were to be opened on 11/3/2024 at 1 p.m. And a right was reserved upon the managing director to accept or reject, within bracket fully or partly, the tender without assigning any reasons therefore. The detailed specifications is also appended to the schedule of the expression of interest. With the disclaimer. There is that clause we said that for the empanelment.
Empanelment, your
That
lordship.
is the disclaimer, I believe.
It's a disclaimer. 29, empanelment shall remain valid for a year.
No, with the disclaimer. That
8, 27, 27, clause 8. No, sorry. One is 20.
It's not an offer of YAIC. With the disclaimer that certain safeguards are to be taken through. And will not be construed as an offer by OAIC. What is this OAIC? Means you. But an invitation to receive responses from the eligibility interest parties on each panel. The general instructions to the bidder. postulates that the empanelment shall remain valid initially for 1 year from the date of the publication of the impaneled list in the official website of the corporation. Extendable for another period of 1 year on the same or mutually agreed terms and conditions, subject however to the satisfactory performance by the corporation. It is the instruction for the proceeds that the applicants must furnish all the information as per the said expression of interest while participating in the impanelment process, and the firms who are qualified with regard to the eligibility criteria. Could be shortlisted within that impaneled by the corporation. Because of these instructions to the bidder, containing the aforesaid clauses relating to the application for impanelment for impanelment to be shortlisted by the corporation, an impression is created into the petitioner that the said tender is in fact floated for impanelment of the suppliers and not for procurement of the said goods. It is straight law that the interpretation of the document that the tool for interpretation of a document mandates the consideration of the documents as a whole and not in a piecemeal manner. While considering the intention, while gathering the intention from the words or the expressions used in the document, the court should not segregate one sentence from either and neither and add it to the other to uphold the condition that actually what it intended. The harmonious reading of the various clauses, the words or the expressions used in the written document should be ensured, and the intention of the maker of the said document has to be deciphered from the meaningful reading thereof. It does not appear from the tender document that the latent intention was to impanel the supplier and not the procurement of the materials, but in effect it was floated for procurement of the materials, the description whereof is given there. which would further be corroborated by the decision taken in the meeting as reflected in the resolution prepared, resolution annexed to the petition. Whether the tender was floated in anticipation of a decision to be taken in the meeting, or in other words, at a anterior time, depends upon the nature of the materials and the requirements in case of an exigencies and or urgencies. The committee ultimately approved the procurement of the said materials, and even though the same was published on the same day, but the last date for submission of the bid was fixed till 11th of March 2024 in that date, up to noon. We do not find any justification that because that since the said tender was floated on the same day of the resolution taken by the committee, would invalidate and or render the same illegal, arbitrary, and discriminatory. The instruction to the bidder appended to a tender document, though forms integral part of the tender, yet cannot be said to dilute the primary intention of the authority, and therefore has to be construed and therefore is relatable to the primary object. The general instructions to the intending bidder cannot be projected affront to destroy the primary object for which the tender was floated, which in this case was for procurement of the materials from the intending bidders. Though the brief description of the expression of interest process is suggestive of the duration of the impanelment, or the impanelment to be done, but the same cannot be a decisive factor to diminish the primary intention of the authorities in floating the tender for procurement of the goods. Several objections are raised in the instant writ petition on the the eligibility of the petitioner being not the SSR, this small scale
Industry.
unit, industry
Yeah.
unit or unit,
SSI industries.
SSI industry, which in our opinion is deholds the cause of action. Stop. The suitability and the eligibility is to be considered at the time of an impanelment. And it is not in dispute that the petitioner is not impaneled by the corporation as of now. We are conscious that conscious of the consequences and or the benefits and the benefits received by the impaneled suppliers who are the small scale industries. And the policy decision taken by the government to promote such industries. Stop. Once the corporation decided to also decided to impanel the several SSIs in order to make a healthy competition in the market, and also to ensure the rational distribution of the benefits arising out of the activities of the corporation. The corporation cannot deny the rightful claim of the persons who otherwise qualify and fulfill all the criteria required therefore. By passage of time, it appears in course of the hearing that the corporation has not issued the supply of the said material by the opposite parties number 4 to 6 and have kept the same in abeyance. Stop. The supply cannot be kept in medio for all time to come, as it frustrates the very core object of its procurement. Stop. The supply shall ensure the benefits to the common people, more particularly the children of the society who are availing the benefits of the Anganwadi centers in the different corners of the state. It is an ardent duty of the corporation to uphold and or ensure such benefits uninterruptedly and continuously, without frustrating its ethos for which such policy was taken by the government, being one of the primary responsibilities provided in the Constitution of India. We do not find any matter having continuing in the corporation in not resuming the supply of the materials in terms of the purchase order issued to the opposite party number 456. So we therefore now it is thus open to the corporation to take a conscious decision in this regard. So since we do not find that the tender is liable to be caused being arbitrary, illegally and discriminatory, as the same was floated on the ground of exigencies and or the urgency having notice by the notice in the meeting held on 2nd March 2024. So far as it was published in a official website.
Official.
Should we go into that the internet access is a wider one, then we'll have to go into that. It's not the conventional way of publishing in a newspaper. It is a wider one. Accessible to globally. Everybody is more wider than anything. If you want, we can make a lot of observations.
Lakshmi, leave it at that.
Better.
Give us the opportunity.
Yes, we do not find any grounds warranting interference. So, however, it is open to the petitioner to apply before the corporation for impanelment. And in the event such application is made, the corporation will take a conscious decision thereupon.
Impanelment for future tenders, man.
Thereupon, no, I'm just trying to. I have a very bad word in my mind. I am trying to find out a milder word. In a flow, in a fragment.
Which one? Great one. Great.
Graduate engineers are taking contract to work of some 5 lakh some odd within work within 5 lakh some odd.
Why you are not paying the
They are
bill?
not paying my dues to last 2 to 3 years. The student will not.
Paltry sum of rupees 2 lakhs and all.
We have
What are you doing? And person has to approve the course for that.
because the instructions, we have instruction period. Now it is under process period, it will be given within 2 weeks period. I have got
Will not see directly. Or after compliance, then report.
Not report unnecessarily.
Ask your lordship presence. Ask your lordship presence.
Item note 5.
No, I don't know. I'm praying for adjournment.
Why?
That's English.
You're getting an opportunity.
Here in this matter, we are praying for and sought adjournment to find counter application.
Why? What is the matter?
The mining officer has requested for 1 time.
Singapore stone coil. Singapore.
No, it's there in Niagara district.
It's not Singapore inside the country where the red flag.
In Niagara district.
There was any direction for affidavit? Yes, affidavit within
2 weeks.
2 weeks.
Item number 6.
Your Lordship, on the last occasion, directed the government to take instruction regarding this road widening, whether they have followed the procedure that in view of the Supreme Court judgment, Mano Siverel Akas, and they have taken time to take instruction in this regard.
Well, our instruction is that we got symbol for municipality. They have a separate set of councils.
That's the instruction.
We need 1 time.
So that you have to ensure that if they were then
Next week. Yes, next week. I'm praying for next week. For government. Or not? Even at monitor. Yes, ma'am. We need one pen. Hold on.
My lord, interim order is there.
In one and two.
One and two. Collector and department. High Court.
You have to see that what you records to guidelines are followed up.
Item number 7.
Council for the events of the development authorities is some time to file it.
One time to and the counter method in this case.
Identical material is also there, it will also prove that it can be tagged, that is 19510 of 2025.
That opportunity of filing it.
I have asked for the
The order dated 23rd of May.
instruction we have sought for management. The Parva's comment which was and we will file the affidavit within 1 week. We will after this.
Second July.
Allocate one WPCPR number 19510 of to sell reliance. It's other set of argument. That can both can be this.
Item number 8.
Wait, please. That was to dashboard and allowed to place the order. The internal order is at annex of 10, page 102. Not,
There was a casualty which happened from the compensation you were required, you were obligated to pay. You are challenging that.
where the collector was directed.
What precautions you have taken? There was a landslide during the mining operation that causes casualty. So,
Not under annexure D series, I made payment of 10 lakhs each to all those deceased persons, to the relatives of the deceased persons. Now that incident was challenged before the London NGT, and the London NGT at page 101. I will just take 1 minute. Page 101 will also kindly see.
250,000 as gracia.
Yes.
So,
To the
three persons who died.
Not so. Now the direction was given to the state government to pay 2 lakh each ex gratia to the deceased person. Now the collector has directed me to pay this amount. Now
You have already paid from your end.
yes, ma'am. I have also included the document.
As per his use, it was paid by Shri opposite party number 8, Shri Sai Balaji Constructions Limited, Your Lordship, not by him. As-
When the NGT has directed you to pay that amount, let's say to the persons who died.
He is the lease owner, Your Lordship, not the state government.
True. Then can you defy the judgment of the NGT? You go and have a clarification from there.
Yes, Your Lordship, I will
With
seek
the
instructions.
liberty to realize that amount from him. That is not there. Once an obligation is foisted upon you. Paragraph 29.
Yes, Your Lordship, I will seek instructions. Your
What
Lordship.
instruction?
As to what has happened after the NGT has passed, whether they have challenged that NGT order or they've sought a clarification, I have no instructions regarding that.
How long you will continue, madam? That this
2
matter is
weeks,
pending
2
for a
weeks
very long
time.
time.
2 weeks time, Your Lordship.
What 2 weeks time?
2 weeks time, have to seek instructions.
He explodes the docket because of this.
Your Lordship, I cannot submit anything in absence of any instructions from the state government.
Yeah, that's a last of that. Have you paid that ex gratia? Why?
That has not been paid.
Then
There is a demand.
can you realize, can you make a demand without the payment? Your right to realize from them does not accrue.
Your Lordship, even I do not know whether they have paid or not, because I have to seek instructions from the authorities, Your Lordship. We have no instructions.
So
Your Lordship.
line of judgment which says that if you want to recover, first you have to
Yes, we
start
have
the
to pay
competition and then recover.
Very. I have to seek instruction as to whether they have paid or not also. In the absence of instructions, Your Lordship, I am handicapped.
Give our attention to the man. That is order. And we can keep it in we are at actually brings original Eastern Bank supervise. Well. Page 101. Page 101. It was directed that the development shall pay estimation amount of 2,50,000 each to the 3 persons who have died from the landslide at the temporary stone dwelling. He submitted that. With the 29/3/2025 and our next sector has been issued by the Deputy Director of Mines, that is in charge in the course of which there will be petitioner to discharge such liability. Additional 1 6 2 weeks. 1 week. 2 weeks. 1 week.
Next Thursday.
Weeks of ministry. Instruction whether such. What's the Russia amount as directed by the National Defense Tribunal has been discharged by the government as reflected at para 29 of the 5. This is background.
July. Item 9.
My lord, I have engaged senior counsel Mr. Bhuyan and he is not available today. Filing is against me.
I think I have a glance to annexure failed.
Already,
It's often.
they have not paid the royalties, several other demands were made, they have not. So in exercise of that rule 33, you have cancelled it.
Yes, my lord. It's available under Rule 36.
My lord, I am challenging the annexure 11.
Yes, letter in the order dated 30th of September 2024. That letter was issued that despite the several notices, the demands have been made to you to pay the unpaid royalty and the other garment dues. You have not discharged.
My lord, in several locations, my lord, I have filed representations. That was not considered.
Have you paid the royalty? Have you paid the garment dues?
No, my lord. But
No.
my lord, come to annexure.
I still think that we will continue to reap the benefit.
From the day of execution of agreement, my lord, I have not operated the lease, my lord.
operate the sand quarry, my lord. What has happened, my lord? Please come annex 2, page number 26.
In annexure 9, my lord, here.
Yes, my lord. Due to some medical urgency, my lord, I could not treat my learner senior.
Like to engage any counsel of.
My lord, on the last occasion, I seek adjournment on the ground that, my lord, due to some medical urgency, I was not available. For that, I could not treat my learner senior. Today, unfortunately, he is not available.
That was on 20th of June.
Yes, ma'am. This is the second time, my lord, the matter has been listed, my lord. Maybe taken on Monday, my lord.
According to you, is a normal period of listing of the matter. Before the matter.
Unfortunately, my lord.
Decided.
Unfortunately, my lord, the senior is not available. This is the reason, my lord. On the last occasion, it was genuine that due to some medical agency, I was not available in town. My lord, on Monday, my lord, he's available on Monday and Tuesday. Monday.
You see order 17 rule 2 of the code of procedure. The ground of senior is not a good ground.
Yes, I'm extremely sorry, my lord.
Ninth. Item 10.
There was S present for the picture. I today passed over. Who? For the petitioner S present, S Behran, Sudarshan Behran. For the
Item number 12.
Will be your lordship has been pleased to grant liberty to file amendment application. I have received till date. I filed it, your lordship. I have filed today. I filed.
And since longer the assessment order is in Italian and this was lordship has already granted stay. Now your lordship directly earlier but to file is requesting to file a I-8 to challenge the virus of the censorship. Today he has filed now.
Today I have filed.
Just now.
Next week. Also, the application for amendment of the rectification is D6, 6 the application, the comments made in the this is the matter in the next week.
Item number 13.
Both the matters.
Both the matters are filed.
Against the.
I'm sorry, I could not. I'm sorry, I could not make it accommodate. There is a batch of matter.
17 December.
Yes, that's right. That's right. Now, kindly have the last matter. This is a batch of matters. So kindly have last matter. This is 13.9 for the sake of only for the sake of convenience.
What WA number?
407 or 25.
Sir, all that together to be heard anonymously, so shortly. Is a common judgment?
Yes, sir, common.
Now several issues. What is the fact
Yes, matter pertains to 2014 selection process
of
this particular yes.
the group B?
Group,
C
it is
or-
called a security guard of
Security guard.
security guard of around 303 posts.
Yes.
Now the next single judge has found that the reservation has not been properly applied. That ought to have been applied horizontally.
Or is that not
Instead-
vertically?
Yes, vertically that has been done. Before getting into the legal aspects in the matter, prima facie, last night I went through the paper and had a discussion. I think Learned Singh is right in holding that the reservation has been wrongly applied. That's what even I felt so. It's a problem insofar as the application of reservation is concerned. It ought to have been done horizontally rather they applied vertically. That may be a mistake. What has happened in 2014, that has happened. That's nothing can be done. There is a situation. Now kindly go to Annexure 1, that's page number 16, that's the advertisement table.
Yes.
Has it page number 16.
Yes.
Now the first one, security guard, total number of posts on the right hand side column, that's a 303. For the reservation, that's a vertical reservation which has been provided for SC, it's 43.
Yes.
For ST, 60, OBC 36, and general is 157. That's a vertical reservation which has been given. Now, what they have done is all this ex-serviceman reservation has been given in general category. That is 74 seats have been given to in general category, which amounts to creation of one more category which is not permissible. Which
Subcategory within the category.
could not have been done in particular category.
That's the vertical one.
Yes, vertical one, they have done it vertically. It should have been spread over in all the categories, SC, OBC, and so on. So now those appointments have been done. Now if you apply horizontally, which ought to have been done in 2014 at the time of notifying this reservation. Now for OBCs, the seats reserved would have been, for SC, it would have been 10. Yeah, I'll have prepared a short chart for easy consultation. Look at the other side also.
Yes.
So SC 43, ST 66, OBC 36, and unreserved URX 158, 303. So as per the circular or the Government of India, this one notification, 24% would be the reservation for this one, which has to be given to ex-serviceman horizontally. Then the category would be number of seats. Kindly go to the next table. Out of 43 seats, 10 ought to have been, could have been given to SC, yes, ex-serviceman. So remaining seats should have been 33. So 33 out of 43, ex-serviceman, if you leave it, the last rank which would have got it would have been 33. So 33, the cutoff mark would be 36 for SC category. So that is the person who has been appointed as a 33rd candidate, eschewing ex-serviceman. That is 36 mark. That's in the last column. Similarly, when it comes to ST, 16 seats, and the remaining seats should have been 50. 66 minus 60, 50. Then the last rank, which would have been 50. Yeah, 56, 40, 50. And the marks secured by that 50th rank candidate was 26. Similarly, for OBC, 38 and unreserved 40.5. This is only a broad picture I am giving it. Now, in the next bottom column, that is the marks secured by each of the petitioners, the respondents in the appeal. The category is also given. First 1 and 2 are unreserved. Third one is OBC. That those categories are there. If actually that is incorrect, definitely they can point out. I have no issue. Then the revised cutoff marks so and so. The marks secured by each of the candidates is given in the next column.
Yes.
If you apply the correct principle of reservation horizontally, out of all these petitioners, out of 19,
only two
would have made it. Yes. That is the only issue. Now the learner single judge goes on the fact. Really go see the direction now.
The difficulty would again
Yes.
arise
Yes.
because I find
Yes.
in the second table,
Yes.
so for else the unreserved seats are reserved,
Yes.
which are earmarked for unreserved candidates.
Yes.
The cutoff marks,
Yes.
effectively 40.5.
Correct.
And two of the petitioners,
Yes.
serial number 4 and 5, belonging to a unreserved category.
Yes.
They also secured the 40.5 marks.
Correct. Correct. Those two would have made it.
Now, sorry, one got 40.1, 5. Actually, the next, I mean, the serial number 5 got more than that.
Correct. Whatever.
So you ought to have been.
Yes. These two would have made it. Subject to other eligibility.
Two difficulties, if there is a tie of a marks
Yes.
amongst more than one candidate, and if the number of the seats are earmarked, then the modalities which is normally adopted is the one who is in senior in age will get it.
Yes.
So it does not ensure that he secure the same marks. There is a tie.
Yes.
So he's to be. So the number of seats are already limited.
But when it comes to you or there are sufficient number of seats were there, I do not want to stand on this technical.
You want to be at a more welfare.
Yes, ultimately, if there are some injustice has been done to some of the persons who would have made it otherwise eligible. As a model employer or institution, I do not want to take such a stand even as an officer of the court. That's what I had a detailed discussion. At the most, the eligibility, subject to other eligibility, two would have qualified initially. Zone of consideration, they would have fallen within zone of consideration. That's subject to
Any of these writ petitioners
yes.
offered their candidature as an ex-serviceman.
I don't think. It's no. Therefore, they are aggrieved.
No. I understand.
Yes.
I'm just asking if they claim to be an ex-serviceman.
Yes.
And it is an admitted position that each category has to be horizontally divided by earmarking certain numbers of the seats for ex-serviceman. Then you cannot go for a cutoff marks in that sense.
Right.
There are different cutoff marks.
Cutoff marks in accordance with the ex-serviceman category only it has to be considered.
It has to be done.
Yes.
So it may come down, it may be up.
It is the horizontal line. In the horizontal. That is not the case.
They go down. That's why I asked.
Yes, that's not.
Any of them is an ex-serviceman.
No, I don't think. I don't.
Your Lordship, I am holding
No,
the
just
brief.
1 second. Now, please see the direction also, just let me for a minute, issued by the learner single judge.
Yes.
At the page number 47. Legal aspect, it's hereby directed that the candidature of the petitioner shall be reconsidered in fresh recruitment exercise. Number 1, he directs for fresh recruitment exercise. Number 2, the said process shall be conducted without displacing or jeopardizing the appointments of ex-servicemen who are erroneously appointed by the opposite party. Again, this court comes to the conclusion that the ex-servicemen have been erroneously appointed. 3, such appointments of the ex-servicemen shall be regularized. He presumes that they are all under the appointment of the ex-servicemen are illegal and they have to be regularized by creating supernumerary posts, and those ex-servicemen will have to be accommodated against by creating supernumerary posts. The which one? That's what is the single judge paragraph 27.
Yes.
The said process shall be conducted without displacing or jeopardizing the appointments of.
All of these ex-servicemen,
Yeah.
I'm just asking,
Yeah.
that's why I asked this question. Any of the writ petitioners
No.
offered their candidature as a ex-serviceman?
No.
Yes.
Shall such a.
Now the courts are deprecating this particular concept of a supernumerary.
Correct.
Yes.
On the legal issue, certainly, learned single judge was right in saying that this one, I do not want on a legal issue, I do not want to argue. It's right in saying that they have done a mistake in 2014. That has happened 11 years back. Now we can't improve or we can't go beyond that. What has been done, that has been done. This is the position. But nevertheless, it will not affect the selection process as it is insofar as these petitioners are concerned, except to would have made it subject to other eligibility. That is the scenario which I am placing it before the Honorable Court and subject to whatever the further direction or consultation. This is all the issue.
My recap 394 of 2020. Only 3 paragraphs I am saying.
The reservations for the ex-servicemen.
Yes, sir.
Having not done so.
Yes, sir.
So he has said that now what is to be done?
Yes, they have already indicated their
Are you an ex-serviceman?
No, madam.
So you are espousing the cause of somebody who has not approached the court. You are espousing now the question is again one who is a sense who has not approached the court, and you are espousing the cause. There is no difficulty, but now by the passage of time, what the equity demands.
Yes, ma'am. We approached this honorable court in 2015, madam. When they have committed the mistake, immediately we came to this honorable board. And our matter was pending because of some reasons that was pending till 2024. And this was decided in this writ petition was decided lastly. My particular case, they have specifically indicated that the petitioner has secured 37% mark. They given the table in their page 19 in my writ appeal, where they have indicated that the ESL.
What is your name?
My name is Gouda. Mukesh Ranjan Gouda.
Mukesh Ranjan Gouda.
Yes,
so
madam.
Oh yes, you have filed 394.
Madam.
That's WA 394.
Yes, madam.
So you have secured is 37 mark.
37% mark, madam, according to them.
The cutoff marks.
Your Lordship, so far as OBC is concerned, they have indicated that is 37.5.
No, they have said
7.5.
Where they have disclosed 37.
Your Lordship, kindly come to page 18 of that writ appeal. Page 18.
Even we consider 37.5.
No.
You secured less marks than the last cutoff one.
Lord, there is my case. My humble submission in 3 paragraphs, your Lordship, kindly take note of from page 18 and 19. Their affidavit, they have filed in the writ appeal, they have annexed me.
What they say?
With my Lord's permission, let me
read.
Yes,
What they say?
that reservation for SC, ST, OBC, NCL at the rate 16%, 22% and 12% has been given as per the Government of India guidelines, totaling 145 posts out of 303 vacancies. Further, from the remaining 158 posts, as per the guidelines dated 4/6/2014 issued by the Department of Ex-serviceman, Welfare Ministry of Defence, Government of India, 24.5% of the total 303 posts, that is 74 posts have been filled up from ex-serviceman candidates who have not been availed any relaxation as per the reservation policy of such and such. But they have indicated
what they say, though in the advertisement we ought to have earmarked certain posts for the ex-servicemen in those categories. But in fact, we have also engaged the ex-serviceman who comes within the zone of merit.
Merit.
And we, that is what if I understood
Yeah.
understand is
Yeah.
that actually we have followed 24.5% of the vacancies to be earmarked for ex-servicemen by virtue of their appointment. It appears to me what they say.
That is our case also, Milord. They appointed all those ex-servicemen on merit, according to them, without giving any relaxation available for other categories.
Ex-servicemen.
Yes, sir. Then your Lordship may kindly come to paragraph 7 of their affidavit itself. They have indicated here that pertinent to mention that petitioner has failed to meet the basic cut-off criteria for consideration for employment. The petitioner placed serial number 322, secured 37 marks. Cut-off marks of the last candidate is different categories are as follows. They have given one table, Miller. Table it has indicated ESM General 31.5 Miller.
ESM?
General 31.5. If they have given it is
an ESM General.
Ex-serviceman General Miller. If
they have not given advertised that.
But they are indicating by this cut-off mark, we have engaged the ESM and without giving any reservation to them, without giving any concession to them. If the ex-serviceman without any concession getting the
how the cut-off marks can be decreased or reduced.
But they have
This is what your contention.
Yes, ma'am. Then they are saying without any concession, we have appointed against the general post all the ESM without any concession or reservation. Now they are saying they have the last cut-off mark is 31.5. If I have secured 37% mark, being OBC candidate, I am also entitled to get the appointment as a general candidate also. Because on merit, they are giving this appointment, Mela. It is, my learned senior has admitted that they have committed the mistake. Once you are admitting that you have committed the mistake, you should rectify this. You are saying that you have given this table. And apart from that, without for the benefit of all, including the MCL, I will place paragraph 6 of their affidavit, where they are admitting 65 post persons did not join against the 65 posts. That is available with them.
You are or under different categories?
All categories, 65 posts are available.
Out of 303, 65
persons, they have issued call letters to on merit. 303 persons, 238 joined, 65 posts are available. My humble submission, vacancies are available. So, then you can also consider all those
persons should be placed there according
then
in that 65 posts. They are numbers.
They can go behind because persons did not join.
The principle of let live and let leave. I am not taking their life, but give me my life.
Yes. Yes.
Live and let live.
Yes. We are not, now we are.
This, how can you go beyond your own pleading? If that is the preaching, you have presented everything. I mean, that even can you go beyond the pleading? You can't improve the case at the bar. You cannot argue the odds what the stand is taken in the pleading. The pleading says that this is what has happened.
Yes.
And the cutoff marks which is disclosed, jury has been reduced.
It is not, I think it's wrongly as put it. If you can
look at it, he says, according to you, there is no indication of a horizontal reservation for the ex-serviceman.
Yes.
But actually, the cutoff marks which have been indicated in this. Yes, that means to all the candidates who offered their candidature in a particular post category, media, ex-serviceman or whatever. So their appointments are strictly made in terms of the cutoff. But if the affidavit shows that so far as the cutoff marks which you have indicated is lower, Then in that event, how can you?
Can I point out? That exactly is the now. Out of 158 seats which are earmarked for general merit, that's unreserved category. Can you see the table?
So 40.5 was the cutoff mark.
Yes.
But you have
That's what-
appointed 30.
Yes, that's what I'm pointing out. That's what I'm pointing out. Out of 158, actually 39 seats could have been given to ex-serviceman.
Should have.
Yes, should have. But what they have done is they have given all 74 seats in unreserved category to ex-serviceman. By virtue of that, from 39 to 74, about 35 candidates of ex-serviceman, they fell into the category of general merit. And that 74th candidate's ranking would be 31.50. But he will not fall under the general merit category. He has to confine only to OBC.
No, that is I understand.
Yeah.
But the stand is that once you have given this chart,
Yeah.
and the chart says that the number of the seats that should be earmarked for the ex-servicemen under the unreserved list, that should be 39.
39, that's what.
Not done.
Yeah.
And 119 should be reserved for the general category.
Correct.
And then you say that if you go by 119,
Yeah. Yes.
then the cutoff marks would be 40.5. That means you have. Oh, you are talking about that if the last candidate of 119 is taken, then
Yes.
he will come under 41. And you have not indicated that who will be the last man of 39.
No, this
You have not indicated.
Yes, no. The 74 candidates which have been adjusted in as against the unreserved category in the ex-serviceman horizontal reservation, that 74th candidates the ranking would be 31.50. Actually, from 39 to 74, they have been done the wrong appointment.
When you do it after, you have to go strictly by advertisements. If you have notified the vacancies, and the vacancies have to be filled up in this way, then can you go?
So, the candidates who have been appointed from a ranking between 39 to 74 may not be right.
There may be many other ex-servicemen who are otherwise eligible to offer their candidature, and because of the advertisement, they chose not to offer because they found ineligible.
Among the ex-servicemen, there is no issue. Among ex-servicemen, there is no issue at all.
Now, that is what I'm saying. That you are really trying to make a, may I say, artificial distinctions in this way when it is not real. I mean, it's not apparent.
If I can put it.
What is patent? You are trying to make it more patent by way of a latent intention.
If I can properly put it again, can you see the table at this one for general reservation?
Oh, I understand.
Yes,
Sir,
yes.
when you make an advertisement,
Yes.
the advertisement in the first column was the advertisement.
Correct.
You have said that these are the four categories, total 303 seats.
Correct.
I am advertising.
Correct.
Somebody has to apply.
Correct.
So anybody who comes under ST, SC, ST or
Correct.
OBC, NPL or unreserved.
Vertical, all vertical.
Not vertical. Then when you talk about the horizontal reservations.
Correct.
Then in that event, the horizontal reservations you have to earmark certain posts within that particular category.
Correct.
For the purpose of excellence.
Cuts
Which you
across.
did not.
Cuts across.
Which you did not.
Yes.
But according to you, which you did.
Yes.
At the time of visible appointment. This is what your case is.
Yes.
That you actually follow at the time of giving an appointment.
Yes.
Now, what is the law of the subject?
Yes. Now the only issue, what they have done is they have given all ex-servicemen instead of cutting across all four categories, that is SC.
In the UR.
UR.
I understand what you say.
It has been given in the UR. UR.
Can you?
No, yes, we should not have. That's a mistake which they have done in 2014, which I can't improve now. That's what I pointed out in the beginning. On the legal, single judge was perfectly right in saying so. But the issue is now all these petitioners which are falling under different categories, they fall under different categories, SC, ST, OBC, and general category. By eschewing this ex-serviceman, let us say we should not have done it. The cutoff marks would be which I have indicated. They would not make it to that particular cutoff marks.
But what is the second contention?
Yes,
Some candidates who did not report nor join the force.
Yes.
and that remain vacant.
Yes.
You not fill up those unfilled posts on the basis of the panel which you prepared of a successful candidate for each category. But the carry forward theory, when the panel is alive,
Yes.
it has a limited duration or a lifespan.
That's all.
If somebody who did not join,
Yes.
and he says 65 posts fell vacant,
Yes.
then those ought to have been filled up from that panel in the order of seniority from ascending to a discussion order.
Absolutely.
So
In any calculation, these petitioners accept.
that means the cutoff marks may go down.
No, that's what I'm pointing out.
Yes.
That would not, that's what I'm pointing out from the table. The cutoff marks would not make any difference. It makes all the difference
No,
here.
sir. In a service jurisprudence,
Yes.
please visualize this.
Yes.
There are, let us proceed,
Yes.
119 seats.
Correct.
According to use there.
Yes.
119 candidates, the marks which you obtain.
Yes.
That would be, in the normal circumstances, be regarded as a cutoff marks.
Correct.
Not difficult.
No. Yes. Yes.
It will be regarded as the cutoff marks in the normal circumstances. Now it appears that in particular 119 seats,
Yes.
this out of 119 seats,
Yes.
say 19 candidates they did not report, not join.
Yes.
Though you offered them,
Yes.
given them a letter of appointment. So that post, that remain or the again, you have to fill that 19 posts from a candidate who comes after 190 in the order of.
That's right. Normally we call it as waiting list or whatever.
So
it is.
naturally,
Yes.
the cutoff marks should vary.
Yes.
If you go further down,
Yes.
19 steps down,
Yes.
then the cutoff marks would also be less.
Yes.
What he says is that if it is less, I am coming within the zone, but you have not done. That is what
Yes.
I understood.
Yes. That's what let me point out. Now, all these cases of all these petitioners, they don't come under any of the other categories like.
No, this is on the basis of this cutoff marks.
Yes, cutoff marks only I'm pointing.
65 candidates did not join.
Correct. That's what I'm pointing.
Maybe 2 candidates in SC, 5 candidates in ST, maybe 10 candidates in OBC, and the remaining candidates in UR.
Yes.
If they come under a particular category,
Yes.
because they cannot jump the category.
Yes.
They can jump the category. Again, it's a hilarious or humongous task, I must say. Because even if they offered in a particular reserve category, if on the basis of a merit, they secured more marks, then they would be transposed into the normal category on the basis of a merit.
Apart from that,
Yes.
It's a greater exercise.
Yes. Now, if I can put it, this one to crystallize the particular issue. Under the general category, what has been notified is 158. Now, actually 39 could have been given to ex-serviceman by drawing horizontal reservation.
Give.
No, could have been given or should have been given. What has been given is all 74 seats have been given under UR category, unreserved category. As a result of it, 74th candidate, that is actually 39 should have been given, 74 has been given. Could have been given was 39, actually given is 74 in the only one category. That 74th candidate actually would not have made it. He has made it by virtue of this wrong reservation, only in the general category. That is ex-serviceman. His cutoff mark must be 31.50. But for that, if you take 39 seats alone for unreserved category, the cutoff marks would be 40.5. So some candidates from 39 to 74, let us take actually which could have been given by drawing horizontal reservation would be 39 in the general merit. What has been done is 74. So 39 to 74, that gap or the excess wrongly given to ex-serviceman. That 74th ex-serviceman's ranking must be 31.50. That is only among the ex-service category.
So now what is to be done? Can we not put the clock back?
No, now the issue would be, now let us eschew the number one from 39 to 44 will have to be eschewed. Let us take their appointment is illegal.
it is for them to.
Not illegal in that sense.
Yes.
If they come under any of the categories or within that particular, they will be accommodated there. There's no.
They have been accommodated from 39 to 74 have been accommodated.
I understand.
Yes,
Understand.
yes.
You could have dissected
Yes.
this particular number of the 74 POS
Yes.
into all these 4 categories.
Correct.
You could not have done it in one category.
Correct.
As you did in Goa.
That's right.
Understand.
That's-
Understand. Now this 74 has come.
Yes.
I'm again saying.
Yes.
In order to clear the I would say the stumble block that we have seen now.
Yes.
Then what should be the modalities, the practical solutions one can have?
Yes.
If they say the 65 posts well vacant, they did not.
Yeah.
Then in that event, somebody who has approached timely before the court, you know the line of judgments of the Supreme Court in this regard.
Yeah.
One who is a fence sitter, one who slept in the slumber, they are not entitled to get the benefits of the whatever the order.
Yeah.
One who has approached the court, they will be. So they are less in numbers.
Yes.
Yes. So what modalities your client would have?
It would be reasonable to first to determine the eligibility by.
Because the difficulty is there is a illegality which is apparent on the face.
That's right. On the legal issue, I am not arguing. I have
It is
to.
from that issue. You have just seen the recent judgment of the Supreme Court.
Yes.
That originated from the state of West Bengal regarding the appointment of the school teachers.
School teachers.
26,000 appointments have
Have been shut out.
Yes. Illegality was projected.
Yes.
So that is what I was just thinking, that what to do. That was a different story because there was a lot of
Fraud vitiates everything that is
fraud,
and
illegality, malpractices.
That's right.
Many things were hit by.
now the government came out with stipend, even that has been.
Whatever.
That's a different issue. And I do not want to get.
So this is what I was. Talk to your client.
Yes.
In this regard, what can be done?
I'll make one more of a proper exercise of all the tables where they would have either could have fit in or can be fit in. By doing all this exercise, still if they don't qualify, because now whatever the circumstance, let us eschew the ex-serviceman.
One who did not achieve even a minimum, I think, if the number is absurdly low, I cannot dispense with the merit. Nobody would like to dispense with the merit.
Correct.
But if somebody marginally knocking the door, as you found 2 of them, and the others are also really knocking. 38, 36. Even at 26 is really at the knock. Then what can be done? It's not that somebody got only 2 marks, he has approached the court and challenging where the cutoff marks is 40. Definitely not.
All are
But these are all marginal.
Yes.
One marks difference or a point in a decimal. So what can be done?
Normally, as you know, the examination and all, when somebody, even the batsman scores 99, that can't be considered as a century. That is
That is the difference in the sports scale. But if you secure 99 marks and the first division marks is to be awarded to you, will you not get a grace marks in your school or the competitive?
It's a beneficial thing, it has to be. Therefore, in the beginning, I pointed out this the illegality which has been
So
committed.
once he says, find out the 65 posts remain vacant at that point.
Yes.
If these 19 candidates.
By virtue of their merit, they would have made it.
No, definitely there. You have disclosed the marks.
Correct, marks we have
The
disclosed.
cutoff marks you have disclosed.
Yes.
These are absolutely marginal.
Yes.
My lord, in my case, though I have secured more marks than the cutoff mark, and they have admitted that.
No, they have admitted too. Who are you?
Yes.
Are you a Manoranjan Putia or?
Yes, my lord, Manoranjan Puntia.
He has admitted.
Yes, my lord.
He has admitted.
Yes.
Yes.
That is, I want to draw.
That we are concerned with the rest 17.
Yes.
We are not concerned with the 2.
Yes, my lord.
Which he has admitted.
Yes.
So you have a little role in this regard. After that stand is taken by them. You seek a.
I'll get instructions about it. I'll have it. Because they have to make it.
I think, find out.
I'll find out.
How it is written.
Yes, I'll find out. You just find out, make some homework on it. Complete the marks and the comment.
Some marginal, some one.
Yes. We'll make some homework and prepare a proper chart and if somewhere in there can be. Well, maybe after 15.
You are meeting since 2000. It's a required. I think it's not unless the. You could not persuade the judge to dispose of the matter before 2024. 9 years it consumed in the docket of the court.
But if minor's permission is there, then your lordship may kindly see the order accept. But
Lordship has also granted us interim order in that our applications. Each and every appointment is subject to the result.
True, but we
have been protected by your lordship.
The way matter has moved.
Yes,
I believe
Yes,
very positive.
Your lordship's intervention now
when
we are happy that your lordship has taken a positive
he
note.
has come and argued the matter a positive result. He will definitely exercise his office.
Perhaps the orders will be issued and
Yes.
comptroller to say that.
The litigation period which has continued since 2014. We hope so that period in this courtroom period.
It's some time at the
Yes,
level, they have
Yes.
to discuss and.
Yes, no, for 2 reasons and till 15 it's a Supreme Court vacation only on reopening on Thursday. I'll make it here physically.
Convenient when you come in during the vacation.
Definitely, I would have loved to be here during vacation. But then after all 2 weeks are left to remain in my.
No, you can come before 15. The note. The SC appearing for in fact, it can be submitted that none of the petitioners responsible except for the two of them would come within the zone of 1 on the basis of the cutoff marks. Disclosed by the recruitment company. He further submits that in fact the horizontal reservation for the ex-serviceman has been rigidly, has been rigorously followed while giving an appointment. And therefore it cannot be said that there has been a blatant violation of the mandate of law. And besides in this regard. We
On the legal issues, because as a law officer, I do not want to. That's a legal issue. We have single judge is right. That's what I want to.
I was avoiding to record.
No, because I do not want to be this one. Let us be, from my understanding as an officer of the court, in my professional assessment, single judge was right.
We fairly submit that the legal points decided in order. Cannot be termed as the wrong principles of law, but because of the competing circumstances, the authorities have adopted a procedure which cannot be said to be per se illegal. Can I?
Very well. I'll let-
He does submits that since none of the petitioner respondents comes, that I have already recorded. The counsel for the respective petitioner submits uniformly submit that out of 303 seats. For this, the advertisement was leaked by the applicant. 65 seats remained vacant as the candidates who were offered the appointment did not join. Yes. We have been taken through several amendments made in the counter affidavit filed by the applicant before the signature. In order to buttress the stand that the cutoff marks that has disclosed is erroneous. But the moment, but we do not intend to go. Into the nitty-gritty of the same at this stage. For the reasons that in the event the 65 posts remained unfilled up, the applicant must disclose their stand and the fleet thereof. So in the event the petitioners can be accommodated in the said unfilled posts, the learned ASG would convey the decision of the authority on the next stage. That's really important.
That's no problem.
This is the matter on
First Thursday after 14th, let's say 16th or 17th.
whichever is date convenient to you, tell us.
July 17th.
Let the note be supplied to us prior to 3 days so that we can file objections.
What are you talking about file objection? This is an appeal. Since he has come up with these submissions, for the reason we wanted, if we have to decide it, we have to decide on the basis of the materials on record. Yes. As an appellate court. Yes. Objection in every sense.
The calculation, yes.
So whatever. I have not recorded the note because that was the.
Yes.
There's a fair thing he submitted. When, tell us.
17th or 24th, whatever suits to the summer.
No, both days are convenient.
24th.
Rather, every date is convenient to us.
24th may have.
24th?
Please.
First.
I'm grateful.
Item note 14.
Please, your answer. What's it going to do appeals? Then request losses to pick up that second one, 583. First is 582, second is 583.
Yes.
Your lordship. Your lordship, this In these two appeals, Your Lordship, the composite judgment dated 8/1/2025 passed by the Honorable Single Judges under challenge. Lordship, may I take Your Lordship to the brief facts of the matter, Your Lordship? This appellant bank, which is in the 583, that is a covered establishment under the Employees Provident Funds and Miscellaneous Provisions Act, Your Lordship. And it is also having a different code, specific code for its own employees, Your Lordship. And in 2003, Your Lordship, 20th February 2003, the government decided it's a district central cooperative bank at Baripada in Mayurbhanj district, Your Lordship. And the government decided that the cadre employees engaged in the large area multipurpose cooperative societies, that is LAMPS, cadre employees who are engaged there, of which the employer was the LAMPS, they are to be taken over as the employees of the appellant bank, Your Lordship. That is a decision of the government, Your Lordship, 2003, Your Lordship. Then 2004, Your Lordship, the management of the bank decided to implement that particular notification, and they have taken into steps for integration of the LAMPS cadre employees as bank's employees, Your Lordship. Then 2005, there's a Provident Fund Enforcement Officer conducted a spot visit, Your Lordship. And
What is the law on the subject?
My Lord's law.
This cooperative societies bank.
No, this is the bank this is relating to the Provident Fund matter, Your Lordship. It is a Provident Fund matter of the employees, Your Lordship. Employees' contribution.
The Provident Fund authorities.
Yes, it is against the Provident Fund authorities. Yes. Then Your Lordship, the Provident Fund Enforcement Officer conducted a spot visit in 2005, and they instructed the bank that since there is some dispute with regard to whether their contribution will be calculated from 2003 or 2005, you start continuing contributions from 2005 onwards. And that was also done, Your Lordship. Then 1/4/2005, Your Lordship, that payment of contribution started for all the employees, including these cadre employees who are regularized as grade 6A employees of the bank, Your Lordship. And then 15/9/2011, Your Lordship, the PF department issued a 7A notice, Your Lordship. The 7A notice is for determination of the contributions which are due from the employers. And that notice period, that period of that notice is started from 2003 to 2011. That is the entire
This is the letter of the Provident Fund authorities.
That is at page 18 of the writ petition.
From 2005.
2005, Your Lordship.
Where is that letter which you said that the Provident authorities, they made a spot inspection and then instructed.
Spot inspection, I have not found. I have not found in the writ petition. That's not disputed. I have not found also in the writ petition. I have not found. But Your Lordship might finally find that annexer 1 to my writ petition, because there was a whether there will
This
be
is the order dated 30th of.
this is Your Lordship
2011.
38 2011, Your Lordship. That's the first order, Your Lordship. That was an order which emanated from para 26B of the Employees Provident Funds Act, Your Lordship, whether the acceptance or recognition as employees whose contribution is to be determined under the Act, Your Lordship. And the order is, Your Lordship may kindly come to page 17 of the writ petition, Your Lordship. Page 17 of the writ petition.
Yes.
The last but two para, Your Lordship. Therefore, I hereby order that the cadre employees of LAMPS who joined the establishment as junior supervisor are entitled to EPF membership with effect from 22/2003, that is the first date of notification, or their respective date of joining, whichever is later, Your Lordship. That is the directive given, Your Lordship. And for this purpose, the second annexer, Your Lordship, that is the order and the data proceeding started for under 7A for calculation or determination of their contribution dues, Your Lordship. And Your Lordship finds in that order I have given, that is the impugned order before the court below also. Okay? So, yes, 7A was not impugned, 7B. Right. Page 18, Your Lordship sees third para, Your Lordship. Whereas for the purpose of determining the amount due for the aforesaid period is 2/2003 to 8/2011, Your Lordship. The employer was summoned to appear before the Court of Regional Provident Fund Commissioner in person or through a representative by this office
notice dated 15/9/2011, Your Lordship. That is the first notice, and thereafter some dates were given, and then the final order has been passed on 16/5/2012. And here, Your Lordship finds page 19, Your Lordship. Because I was also agreed, amongst many things, there are two specific things which I will point out to Your Lordships. Page 19, Your Lordship. Para 4, Your Lordship, from the top. Of course, I will take Your Lordship to para 3, Your Lordship. Whereas during the course of the proceeding on 29/11/2011, the employer contended that since the junior supervisors of the establishment were drawing salary from their respective lamps for the period between 22/2003 to 3/2005, the present employer should not be made liable to shoulder the financial burden on account of administrative charges and employer's share of contributions. This was the sole contention because their employers were different, Your Lordship. We came to the employer, be the employer after 2005 or their date of joining, which were later. And then Your Lordship finds, whereas Sri Rasmi Ranjan Jha, the area enforcement officer and the departmental representative, Hyde is report dated 23/11/2011 has submitted a statement of month-wise wages and the deposit particulars for the period from 04/05 to 2008/2011.
Out of 147, that's a no.
19, Your Lordship.
Yeah, about 28.
Yes. Now, yes, that Your Lordship is correct. But Your Lordship, there Your Lordship may find kindly that it is confirmed in its note dated 16/5/2012. Your Lordship may kindly note this. So there are two documents which were prevented from us but used in this proceeding, Your Lordship. That is, first is that report dated 23/11/2011, that is in the 4th para, and 5th para, the note dated 16/5/2012. And both these authors of both these documents were the PF inspector, Your Lordship, who was the department representative. And on the basis of these two documents, the next page, Your Lordship, may kindly come to page 20. Page 20, Your Lordship, next page, Your Lordship. And the table is there. That what is the determination, what is the dues, Your Lordship, dues question. Now, Your Lordship finds that is 1,32,99,662. Oh, sorry, 1,32,99,362. 119,73,234. Your Lordship finds just the previous page. Just the previous page, Your Lordship has pointed out that it was 1,47,000. 47 lakhs, Your Lordship. So there is a dispute and difference also, which was because we could not be aware of this, Your Lordship. And there is a proof.
The penalty or the interest have been included.
No, penalty is separate, Your Lordship. This is interest is the second capital.
14 lakhs, the differential amount was 13 lakhs.
13 lakhs. 28 lakhs, Your Lordship. 28 lakhs. Cumulated, it will be 28 lakhs, Your Lordship.
They have reflected.
Yes, Your Lordship. 28 lakhs. Then, Your Lordship, there is a provision, because there are two provisions which are available under the EPF Act. If you are aggrieved by any 7A order, Your Lordship, but or this determination, one can move an appeal, Your Lordship. That will be under 7I. Or if there is something which is coming to the notice of the employer for the first time, or something which has been missed in the order, he can file a review of the order also. So we chose the review, Your Lordship. And the review has been filed, Your Lordship. And with also details, the file was, then the Form 9 review, Your Lordship finds, para page 30, Your Lordship. And there is a statutory form, Your Lordship. Form 9, Your Lordship, is there. And then the grounds also finds, Your Lordship, as 32. Separate annexer, Your Lordship. Annexer 1 to the review. Your Lordship, the review has been rejected, Your Lordship. The review as rejection order is at page 36, starts from page 37, Your Lordship. And against this review rejection order, Your Lordship, the scope is against the review rejection order, there cannot be any appeal filed, Your Lordship. Appeal cannot be filed against review rejection order, but the writ petition is maintainable, Your Lordship. My Lord, thereafter I filed this writ petition, Your Lordship. And this writ petition, Your Lordship, there was also interim protection, Your Lordship, with interim stay granted for against any recovery of the amount which has been determined, Your Lordship. And ultimately, Your Lordship, what has found during pendency of that matter, Your Lordship, three employees who are retired employees, they find a writ petition.
7Q.
7Q is interest, Your Lordship. 7Q is interest.
So, the bottom line of the interest, so that it appears from the your stand taken before the revision is stopped or review authority. 40.
Yes.
If you admitted your liability of.
We admit your liability, but we want a determination, Your Lordship.
No, sir, you admitted the liability of the deposit of the differential amount. But you wanted a waiver of that particular income.
Yes. No, sir. That is Your Lordship.
Second line from the top.
Yes, Your
The establishment representative is submitted.
Yes, Your
That
Lordship.
is duty to deposit the amount under section 7A, that is the differential amount.
Yes, Your Lordship.
But wanted a waiver of the amount assessed under section 7Q.
My lord, this thing I have
Component.
challenged also in the writ petition saying that there is no such statement.
If you have consciously taken a stand.
No, it has not taken.
Deposit the amount.
No,
Can you take a?
No, I cannot take a U-turn, Your Lordship. I cannot take a U-turn. I'm sorry that we cannot take a U-turn, Your Lordship. But we have challenged this amount, this statement also, that no such statement was authorized to be given to Your Lordship. In the writ petition also that was taken. Yes, that's what we have indicated in the writ petition specifically. No, because there is no such. After review is rejected, Your Lordship, we cannot approach the same. No, there is no such provision, Your Lordship. There is no such provision in the Act, Your Lordship. But that is not there in there. We have not taken, but we have taken in the writ petition, Your Lordship. We have taken in the writ petition specifically.
There is nothing in the statute, but it is not. Can we absorb the authority? Correct the ministerial error.
Of course, Your Lordship, to my experience, Your Lordship, there is no such thing, Your Lordship. Yeah,
there are judgments from that law.
Yes.
That the power.
Yes.
Power
of review. Inhered into.
Not be a specific provision for that. Inhered.
Yes, like section 151, Your Lordship.
There is a numerical
Error.
In arriving at the calculation, apparent on it.
On the face of the record. On the face of the record. But this is one part. The other part is, Your Lordship, we have given the reviewing authority specific names, Your Lordship, that these are the names. And specific authority, we have given the specific names that who are our employees, but kindly determine that against whom will pay how much, Your Lordship. That was the crux of the matter. Yes.
The issue which you are raising.
Yes.
The regulation, you are looking at mandate to start contributing your part of the obligations.
Yes.
Under the PA, from 2005. Right around the issue of the proceedings, they wanted to impose an obligation from a retrospective.
Three.
Proceeding was initiated. And thereafter, contributed in court went to the if you, before the review authority, if you abandon or obey your right, it will say that yes, I will pay.
That thing I have stated.
That means the stopper will come way.
Yes.
So you cannot retract from the stand which you took.
I know. That is there, Your Lordship.
Then you have to remove the stopper.
Yes.
If you have to remove the stopper.
We should have moved that particular authority.
Who was the representative?
Yes.
Who was the representative?
Yes.
Appeared before the
Authority.
Whether this representative was competent enough to convey the conscious decision of the
Right.
Or the corporation,
Yes.
If he had the authority, then
My lords, with the due humility, I must say that any representative, he cannot improve upon what is there on the pleadings, Your Lordship.
No.
Pleadings is not there.
Convey the decision of the authority.
No.
The only thing is that yes, I am agreeing to. The decision. But if you, before the review authority, if you want to remove the stopper, who was the representative?
I know.
Who was the representative? Yes. If you have to remove the stopper, who was the representative? Yes. If you have to remove the stopper, retrospective operation of my contribution and situation, whatever.
Well,
Under the.
sir.
But please wait, because there was no fault on our part.
So waiver is one part, Your Lordship. Waiver is with regard to interest, Your Lordship. But with regard to the principal, Your Lordship. Right.
Question is not a principle.
No.
Question is the operation of an obligation or a liability from a particular date.
That is also not disputed now, Your Lordship.
No.
That's not disputed, Your Lordship.
No,
Right.
you have not disputed that your liability is reckoned from 2003.
Three, that's right. That's not it. That's not, I'm not on that point also.
No.
The point is, Your
That
Lordship.
you admit.
Yes, that I admit.
Correct.
That I am liable to pay, Your Lordship.
The
Yes,
question is
yes.
Position of the interest.
No. There are two parts, Your Lordship. The first is the determination of the entire liability. Determination and interest flows from the determination, Your Lordship. Interest flows from the determination.
Determine.
Yes.
Can you say
Right.
that the amount should be less than what you have already deposited?
That also I don't say, Your Lordship. That also I don't say, my Lord.
Because
Right.
if it is to commence from 2003
Right.
and not from 2005,
Right.
then between 2003 to 2005,
Yes.
your obligation was contribution will be.
Yes, that limits. That limits.
There must be some amount,
That limits.
that there must be some amount.
Yes.
May not be 30 lakhs, it may not be 12 lakhs.
Whatever.
You are-
There must be
you are
something.
determination.
Yes.
Quantum.
Yes.
Can the rate court go into the such the nuances?
No, I'm not going down to that.
Quantum.
I'm not also going on that one also.
Yeah.
Because my whole difficulty was that if X amount is also imposed on me, then I am to get it back from the employers at the relevant time, Your Lordship. Employer of the NAMs, Your Lordship, of whose the employees were there. That is my prerogative.
Can't be decided there.
That is under the
Because
authority, Your
that
Lordship.
cannot be. You're right. You're right to accrue to recover the amount from a particular ability.
Yes.
Who is under the statutory obligations to
Yes,
pay.
yes.
Will definitely accrue only after payment.
That is what has happened in this case, Your Lordship.
After payment.
Man, that is what has happened, Your Lordship. What has happened, Your Lordship? I'm just.
First you discharge your obligation.
No. First is that, Your
And
Lordship.
then you chase the lab that it was your obligation, you pay me back.
That is exactly that. Which lamp will pay how much? That is not there in the order, Your Lordship. That is.
That was not a.
Because Your Lordship sees for every determination.
The authorities, please continue.
Man.
The authorities
Sir.
cannot transgress their powers
Yes.
and decide something which is beyond the statute.
No, it is in the statute itself, sir.
When 13, listen, I-
Sir. Yes.
When they came forward, let's say that you are the organization comes under the Provident Fund Act. And you are obligated to pay your contribution or deposit your contribution.
Yes.
The question was that from this date the contribution was there because they have initiated a proceeding against you.
Yes.
Please continue, sir.
Right.
As a litigant, you could have taken a stand, and I am sure that your client must have taken a stand before the Provident Fund Authority that your liability accrues to me prior to 2005 when the entire organization was entrusted upon me.
Yes.
Prior to 2005, it was the lab who was
That is right.
aware of that.
Exactly.
So my liability has not started or commenced there.
From 2003. Yes.
The authority must have said, no, I am not agreeing with that. Your liability remains your activity.
Yes.
You challenge the order. Before the authority.
Before Your Lordship goes further, I will
Before the
take only
authority
one.
said, yes, sir. Now I.
No. I will take only one moment, Your
I
Lordship.
will pay from 2003.
No, my lord. No, my lord. That is not my case, Your Lordship.
Then
I am not my case. My lord is.
Your representative said.
No, Your Lordship. One point is that, Your Lordship.
That's true.
There is one point. We are missing one point, Your Lordship. My lordship, I am missing one point, Your Lordship. The whole thing is that these are all for beneficiaries benefit for the employees, Your Lordship. They are the beneficiaries. So that is why the determination is important. Yes. Beneficial. That's right. Exactly. So in that case, Your Lordship,
I am still stuck up at your admission
Your Lordship, there are 52 lands and the beneficiaries are there against them, right? But whoever.
Whom you will, sir.
No, but that's right, sir.
The liability is foisted upon you,
Yes.
which you admitted.
No, that which has been foisted, Your Lordship, that is on the basis of 2 reports which were not given to me. So I am not.
I don't
there.
know.
Yeah.
You could have challenged that.
Madam, we have challenged that, Your
No,
Lordship.
then you say that.
There is that statement which has been recorded, Your Lordship.
Statement
Yes.
that the establishment representative submitted that he is ready to deposit the amount under section 7A.
Yes, Your Lordship.
But.
Wanted a waiver, Your
The
Lordship.
amount
Yes.
assessed under section
7Q, 7Q.
There is no provision of the waiver of the amount under 7Q in that.
No.
And the scheme breakdown. So
No.
the amount cannot be waived.
No.
So once you agree
No.
that you are ready
That
to
is-
pay the principal.
Your Lordship. Against
as
that, Your
determined
Lordship.
Under 7A.
Right. Against that, Your Lordship.
Can you say that yes, you have determined, but why forget my liability?
No, Your Lordship, may kindly just see para 7 of my writ petition at page 5, Your Lordship. Just I'll take Your Lordship to that point. Para 7, Your Lordship. Possibly 10 lines from the bottom, Your Lordship. It is specifically denied, Your Lordship. Does Your Lordship get? It is specifically denied and registered that the petitioner's representative had ever agreed to pay the PF dues as assessed earlier in the 7A order, but had expressly asked.
Did you submitted the affidavit of your representative that this submission was ever made by
One
or the representative is a deponent here?
No, he is the secretary, Your Lord. The deponent here is the secretary, Your Lord, of the bank.
And for the.
He was a manager, Your Lord. He was a manager, Your Lord. Yes.
Did you secure these affidavits and annex to the rate petition?
No, that was not annexed. That was not annexed, Your Lord. That was not annexed. I must be fair, that was not annexed. Not annexed.
Being your representative
No.
is an agent.
That is why we have said that he was not authorized to annex
Can
the
a third party without this?
That is a recording, Your Lordship. That is what we have stated. It is specifically denied and registered. And that has not been countered by the bank of Yes.
Binding on the principal.
That is of course of the Mokalatnama is what we write. It's the same thing, act of representative. That's right. But if he gives some, but if he gives any wrong statement or statement which
should come say that could have secured the affidavit from him.
Right, that has not been, that is not on record, Your Lordship, because.
Say that yes, I never made such submissions, I never.
That is not because I cannot improve upon what are the facts, I cannot improve upon that, Your Lordship, I must say. But this is a matter, but one thing is that to support this also, because we have given the names of the beneficiaries which we are aware of. That is why we said that against these beneficiaries, you kindly identify the beneficiaries and for whom what amount will be paid. This total, from to total amount, what amount will be paid. That is the matter before the 7B authority, Your Lordship. And he has also a right to go into that also. That was not gone into it. So he said that there is no matter because no subsequent fact is revealed, so this is no ground for review. That is how it is rejected, and rightly Your Lordship says that it is agreed by the representative that they will pay the amount. So waiver is not permissible under my law, so I cannot do it, Your Lordship. So that is they are the two things which are there on record, Your Lordship. And against that, I filed this writ petition also. Because these are the things which are grievances which are made, Your Lordship. Now Your Lordship sees there are
So all about seven, one is doing an incorporated in subsection 1 or section 7.
Yes. Your Lordship. It's there. No, it's there. That is why I had taken the grounds also specifically in 7B order, Your Lordship, application.
Yes.
Unfortunately, why I am before Your Lordship is that all these things which I submit before Your Lordship, that has not been incorporated in the judgment which I have included in this case, Your Lordship. It has not been included, it has not been, my case has not been touched, Your Lordship. There are two petitions, Your Lordship, writ petitions. One is by the employees who claim.
On what ground the review was filed?
Review was filed, Your Lordship. Your Lordship may kindly come to page 38, Your Lordship, of the judgment, Your Lordship. Errors apparent on record, Your Lordship, which I had indicated because there are two. I had shown the two reports and notes which was not given to me, Your Lordship, and the discovery of new and important matters of which I placed at page 24, 28, 29, and 34 to 35, Your Lordship, of the writ petition, Your Lordship. I had indicated the facts which were not there in the 7A authority, before the 7A authority. And
was it placed before the 7th authority?
yes, yes, Your Lordship. All these documents were out, but none has been touched here.
What is the pleading with regard to discovery of new and important
No, just Your Lordship may kindly come to page 54. Review application. Yes. Here. Here. Point number 5, Your Lordship, at page 32, Your Lordship. From 22/2003 to 31/8/2011, a good numbers of grade 6A employees who were served in different lands have been retired, died, or taken voluntary retirement. As per our record, it is found that out of 100 numbers grade 6A employees, 32 numbers employees have been retired, one has expired, and one has taken voluntary retirement, and one has not joined grade 6A service. All financial benefits in respect of the above 35 number of employees have already been settled. Hence, charging dues, contribution dues in respect of these employees should be waived out. The detailed employee-wise list is annexed herewith and marked as annexure 1 and 2. Because they have said that they have not identified the beneficiaries.
Where the documents which was available prior to the order part of the section 7E.
That was because we are not aware that what is content.
You have said that
Yes.
despite the two divisions, you did not get it. Where is the above that how you got to know?
It is after the record, after the passing of the 7A order only. After the
How
passing.
you got it?
Because we had to say that for whom employees these
Fragment of one of section 7B.
7B. Yes.
We are discovery of new and important document is not.
No. That is not that. That
You
must
have
be.
to satisfy the due diligence doctrine as well.
Yes.
Okay.
My lords, your lordship sees for one moment says 7A, that the 3, that 7A subclause 3 is there, your lordship. Because that.
Please look at the.
Yes.
Due diligence clause.
Due diligence clause, yes.
Look at where is the due diligence?
Fine. Your lordship, the 3 and 4, they had, because all of this came to my knowledge after the 7A order I have received, your lordship. Yes.
And why it did not came to your knowledge?
My lord, because there is a difference, your lordship. No, because nothing was supplied to us, your lordship. They had to supply. No, these are two concepts, your lordship. One who was employed in the lands before coming into a person as our employees, your lordship, but have retired, your lordship.
When you take over this particular
Entire organization. Yes.
Take over all the documents as well.
All
the records which were maintained by the lab is also transmitted to you.
Yes, of course.
These were the records available to you even at the time of ceremony proceeding.
Possibly, my lord, your lord, because
Handing over ceremony proceeding originated.
because your lordship, because My lord,
After 2005,
my lord, these record, which is at page 34 and 35, there are two. This is retired and death list of employees under grade 6A of 435. Because I am trying to distinguish in the 4B, section 7B, your lordship. Because this is a total list or total contribution due, your lordship. The beneficiaries are not identified. The names of the beneficiaries are also not there. Yes. Yes.
Review
Yes.
is not intended for the purpose of rehearing of the matter.
Not rehearing.
Reopening of the matter,
No.
or revisitation of the matter, or for rewriting of the order.
No.
Never.
If there is something which is lacking, your lordship.
Yes. The statute does not really contain any kind of a prescription.
Right.
Then in that event, the reviewing authority.
Can do.
Administrative or
Can do.
prosecution authority
Can do.
decide about.
Can do.
But subsection 1
Yes.
really puts the grounds on which the review can be done.
Right.
One is,
Right.
when you talk about the error apparent on the face of the record.
Yes, your lordship.
Then in that event, you have to show that these are the papers which are already there on the record.
Right.
When 7A proceeding has been initiated and decided,
Right.
and there has been a complete omission on the part of the authority in taking note of it.
Yes.
And the observation which he has made is contrary to that document.
Yes.
It's an error.
That's it.
An error that goes in the root.
Root of the matter. That is number
That
one,
you
your
have
lordship.
no.
Yes.
Secondly, you say that there was a discovery of given importance.
Yes.
Subsection 1 says that
Yes.
yes, review would lie, no doubt. But with the conditions that you'll have to satisfy that despite due diligence, this document was
Not within my
your
knowledge. Not within my knowledge.
or by any reasonable
Cause it could not have been placed before the
not have been
authority.
brought to the bar.
Right.
Was just trying to understand that the amendment in the reviewer.
Yes.
Here, finding a new document will not do.
No. The whole thing is that, your lordship, those two documents which has been relied upon, that is the report and the note, your lordship, they are never made available to me. No.
What's supposed to be the custodian?
No.
If you
My
are
lordship,
not,
no.
then how you obtain that document?
No, my lordship.
From what source? you
What I am
obtain?
talking of, your lordship, these are the note and report submitted by the department representative before the authority. That was never permitted to be placed before us, or we are not aware of that. I am talking of that document, your lordship. Those two documents.
Is that document ignored to your benefit? If it ignores to your benefit, was it what this document?
These two documents are after the hearing was over.
Placed before the 7A authority?
Yes, your lordship. That is reflected.
7A authority took note of that document.
Yes.
Took note.
Yes. Without serving a copy on us.
How you say that these are the new and important documents?
No, these are without, this is after the date of hearing, your lordship. Last date of hearing.
So
After the
before
last.
judgment is pronounced.
Yes.
Was filed.
No. Same day, your lordship sees. Your lordship, for a moment, your lordship, have a glance at page 20, your lordship. So, 11. 29.
What is Rahul means from the Bhadra's
Governor's case, your lordship.
decision of the Supreme
Your lordship. Your lordship says page 18, the date of the order is 16/5/2012. That's 7A order, your lordship. And the note your lordship finds in page 19, that is also dated 16/5/2012. And this is long after the hearing was over, your lordship. I could not know about it, your lordship. That is the crux of the matter, your lordship. It starts from that only, your lordship. And prior to that also, there is another. Appeal, of course. Because I said from the very beginning, there are two ways. So if I can.
If you choose one.
Yeah.
Then you have to restrict to.
Yes. I am not saying about the appeal now, your lordship. I cannot. No, yes, I know. Because if there is a.
Against the order.
If there is a.
Can also file a review you can also file a.
Appeal, Your Lordship. Yes.
Can run simultaneously.
No, cannot run simultaneously.
No.
No.
CPC thing.
Yes. Your Lordship
If
sees.
you want, I can show you both.
No, Your Lordship.
Even-
I'll.
Even I'm telling you.
Yes.
The CPC.
Yes.
Party order which is passed.
Yes.
One can go on the order 9
Rule 13, Your
and one can also file an appeal under section 96.
That's right. That's
Both can run simultaneously.
Yes.
But the catch is.
Yes.
If the appeal is dismissed fast or.
Naturally, it goes.
Then it will.
Your Lordship is correct. Here, Your Lordship.
Then the.
Here also.
Order 9 will go.
Well.
Even the review will go.
My lords, here the 7B starts with, Your Lordship. Your Lordship, 7B starts with any person aggrieved by an order, but no appeal is
Most appeal is filed.
Yeah, appeal is filed.
The review is a maintenance.
Mentioned. Yes.
Right.
Yes.
Their filing does not really.
No. That's right.
Remain a cause.
The effect will be the order, Your Lordship, ultimate order.
Impact would be.
Impact will be the ultimate order, Your Lordship. Yes. Yes.
There
So-
are decisions that subsequently they may withdraw appeal
Yes.
and proceed with the review.
Right. Your Lordship is correct.
So that is permissible. Filing is not a bar.
No. That's right. So I'm.
The difficulty is that this is where the appellate for.
No, fact remains that I have not
But it
read.
is restricted. Again, I'm saying.
Man.
Had it been a simple provision relating to power of review,
Yes.
you would have appreciated what you said.
My lords, here is that if any appeal is not filed, then you can file a review. That is
But
the provision.
review is restricted on the 3 grounds. One is the error apparent on the face of the
Yes.
record. Second,
New and
the
important documents.
Important documents.
Yes.
Without you, diligence was not within your knowledge.
Yes.
And the third is for any other substantial cause. Or a reason.
Right.
This third one that has been interpreted constantly is relatable to these two. Even a recent judge.
Correct.
25 volume 4 SCC.
Yes.
So that's not a.
No. It's not at all tell, Your Lordship. Right. Here, Your Lordship,
So that is the problem where we stuck up.
No, that's right. I could know, Your Lordship. I could know, Your Lordship. Here, Wallace, why I am before Your Lordship again, I am saying that the judgment starts with page 37, Your
That's a
Lordship.
good case, but.
Well, we have 37, which is.
Once you chose for a review, I think.
No, my lords.
You would have taken a plea that the document which was not relied on, nor the opportunity was given.
Then I'll take Your Lordship. Then I'll take.
Taken it in an appeal, but review.
No. I'll take Your Lordship to page 44. Your Lordship, may kindly have a look at page 44. That is the conclusion, Your Lordship, of the impugn judgment here.
Page 44 of.
44 of the brief, Your Lordship.
WA.
Writ appeal. WA. Judgment, Your Lordship. Impugn judgment. With the Honorable Single Judge. In light of the foregoing, the writ petition, that is WPC number 2948 of 2017, is allowed. Considering the prayer of the Cooperative Society Bank in WPC number 21974 of 2013, this court refrains from delving into the technical intricacies of the case. Instead, the Regional Provident Fund Commissioner RPFC is directed to calculate and determine the accurate amount of EPF and other dues. I'm just saying that here. I'm just coming to that. Why I'm before you. Owed to the petitioner and similarly placed employees within 2 months from the date of presentation of this judgment. The Cooperative Society Bank shall thereafter disburse the calculated amounts to the petitioner and all concerned employees without fail.
Why your authority is set tight?
Yes.
Time on.
Why you are sitting tight? Against this order.
Order might be passed. I'll check up on the department.
There are two provisions in the Act, Your Lordship, as I have said, 7A and 7B. And this doesn't come into any of these because these two orders are there, Your Lordship. Now they have to give another notice, Your Lordship. If they do it, then they.
I think that why you are
Yes.
silent.
Yes, Your Lordship.
But you are active, you have activated yourself is the real question.
No, my Lord, sir.
I think you are a beneficiary of this order. The real agreed person would be there. The only agreed person is the interest company.
Of course, Your Lordship, I cannot waive out. I cannot avoid, Your Lordship. I cannot avoid. No. I cannot avoid. Legally, I cannot avoid.
Even your liability to disburse the amount is postponed by an order. Just imagine.
But only thing is that, Your Lordship, what is the provision, Your Lordship? This is the.
Can the court do it?
Right. That's the whole part. That is the unfortunate part, Your Lordship. Which provision, Your
But
Lordship?
still you are a beneficiary. You are benefited by.
Ultimate liability will be also come, Your Lordship. That I don't mind.
That will automatically
come, Your Lordship. Yes.
The single bench ought to have.
Stop.
There.
Yes.
Let's say the amount is there, you take care of this, you have to take the pay.
Right.
But again, the ball is rolled in their court to make a calculation. What is the entitlement of those persons, petitioners, the quanta, and after the determination,
Yes.
your liability to disburse the amount will arise.
Yes, absolutely. And I am to be heard in the matter also.
He's
In the
for-
process. He's for the Provident Fund Commission.
That's what I'm asking.
Yes.
No, bank.
I am for the bank.
He's coming.
I am for the bank.
He's benefited.
Lamps are not a parties, Your Lordship. Not in the 7A also. They were not parties.
Has not said it.
Appeal, no, lamps I have not made parties.
Well,
Lamps are never parties, Your Lordship.
never.
No.
The retribution
No. Respondent number 2. Is the enforcement officer, Your Lordship, BPF organization.
I get 3, 4, 5.
583, Your 583, Your Lordship. 582, 582 was filed by the employees, Your Lordship. Those employees, Your Lordship. He has made his lamps as employers as parties, Your Lordship.
582, you have
582.
the lamp as a party also in the.
No, Harris? 582, because they were parties in their writ petition. Because they were in the parties in the writ petition. One lamp only, Your Lordship. That is Kanti Sai lamps, only one lamp. In 582, the petitioner was a respondent number 3, Your Lordship, 582. Yeah. Minutes.
Will modify the order, don't worry.
Minutes.
If you are agreed, will modify the order, confirm the order of 7A. And the revisional authority, that's a review authority, not able. Not able. Pay.
May make
Not to have done it. Single base should not.
Should not have- That is why I am
Because
before.
it is beyond the scope of 7A.
That's right.
They cannot.
They cannot.
So we will.
Because Your Lordship sees, Your Lordship is right.
The order of 7A and 7B.
Your Lordship is right. 7A, 7B order being there, this order could not have been made also. That's what I'm submitting. Yes. That's why I'm saying. That's why I'm before.
Look at the plight, what you are doing.
May-
If we accept, it is more.
No. That will be difficult, Your Lordship. Yes. So may I make a humble prayer, Your Lordship? I'll make a humble prayer, Your Lordship. I'll not press this one now, but I'll go for appeal, Your Lordship. That liberty may
I do not know what appeal.
appeal against 7A order, Your Lordship.
I do not know whether it is permissible or not permissible.
Because 7B, once it is rejected
I
also.
do not know because I have seen. provisions contained there.
7I is there, Your Lordship. 7I is the appeal. Your Lordship.
No appeal lies against the rejection of the review.
No, rejection order against, no, there is no appeal. I'm not going against the rejection order, Your Lordship. 7A, I cannot, 7I, I cannot file against rejection of review, Your Lordship. I can only file against the 7A order, Your Lordship. Whatever is wrong.
And that right.
That liberty mechanism.
With certain riders.
Because you see, Your Lordship sees that on this period, that has to be taken into consideration only. That is the only thing, nothing else.
We know.
And appeal against, I am to deposit certain huge amount, Your Lordship. I'll have to take.
The difficulty I think.
My Lordship.
You wanted something which you know that cannot be done. Even a section 14 protection you can't take.
I know it.
Section 14 only
Damages.
when you have approved the wrong forum.
Yes.
The review is provided in the statute cannot be said to be a wrong forum.
No, that is right.
So why section 14?
7B is there. But Your Lordship, why 7B order has not been considered, Your Lordship, that is why I am before Your Lordship also. That rejection order. I am against.
You take advantage of 14 of the resolution.
No, not 14 Your Lordship.
That pursuing a remedy before the other forum is not a wrong one. Perfect one.
No, that's right. 7B is there, Your Lordship, because I have gone rightly also there. Still, I say that I have gone rightly, and I have pointed out the errors are also, which are apparent on record in 7A order also. Because I am also interested that my employee should get the money also. The determination should be properly there. That is the only thing.
They have been given a task.
Exactly. That is why I am stuck up here.
Given a task of determining on the respect of a petitioner.
Your Lordship may direct within a particular time.
The paragraph 16.
16. Yes.
What more? What more direction you want?
16 is there, Your Lordship. 2 months there. And that is already passed, Your Lordship. Let them do it within a particular time.
Commissioner will take care of that.
Yes.
What will do?
Yes.
We have to dismiss the appeal. Nothing more than that.
I can only urge upon Your Lordship to grant them little more time so that we can also be heard in the matter, so that the matter can be disposed of.
More hearings, sir.
Hearing means, Your Lordship, with regard to quantification.
Calculate and determine the actual amount. Yes. Paragraph 16 is correct in that sense. Yes. That, this direction cannot be made.
Yes.
Because the jurisdiction cannot, or the powers cannot be conferred on the authority, which is not conferred by the statute.
Yes.
The statute does not permit. Then how that power can be conferred by an order of the court? So we will simply set aside this portion of the order and affirm the order of 7A and 7B.
Yes.
Let the ball is rolled, immediately take all coursive steps against him.
Yes.
Seven I.
7I, yes.
7I does not talk about.
No, the rules are scheme.
Oh, as they be
As the
prescribed.
prescribed
There is a
rules.
prescription.
Rules is there. For the appeal rules are there. Appeal rules, last. Applicable, yes. Tribunal procedure rules, Your Lordship, 1997, Your Lordship. $60 days, Your Lordship. 60 days, Your Lordship. Rule 7, 2. Rule 7, 2, Your Lordship.
Power to control.
Your Lordship, power to control is proviso, Your Lordship. 60 plus 60, Your Lordship. Total will be, Your Lordship, 120 days. And again, the appeal will be admitted unless that 75% is deposited.
With an outer cap given beyond which it belongs. No liberty will suffice.
Yes.
It is mandatory. What do you do now? Yes. Yes, you pass the order and not be well in trouble. You just say.
Great.
Okay.
May I please? Where I'm challenging the order of the Honorable Single Judge. 14/11/2024. 24. My lord, just before that, my lord, a selection notification was issued and I made the application because I was 4 days older than the prescribed age. Then my application has not been accepted by the through online. I approached this honorable court in earlier writ petition, and that writ petition, when that writ petition was pending, they have accepted my application. Then I participated in the selection, qualified in the written test, by everything, but provisionally also list was published, but final list my name did not appear. For the post of 972 post, that advertisement was issued by the state's selection board on behalf of the higher education department, and I am concerned with the lecturer of Sanskrit block. Then I have applied, but that was initially has not been accepted. Therefore, then I came this honorable. But what happened? Earlier writ petition, I did not press it, and that was dismissed. Now, when they did, even after provisional select list, they did not list my final. I did not find place in final seniority merit list. I approached this honorable court, and this honorable court, page 47, that order of this honorable court, in subsequent writ petition 4252 of 2022, it was dismissed only because your lordship may kindly come to paragraph 6, page 49. May I please?
So what is it, 19, 29,
Mila.
14049.
Yes, ma'am. That is passed in 14049 of 2020. That if a lordship will permit. Well, first two pages are there. That read petition, along with the read petition, that is there. First two pages. The Honorable, your lordship may kindly turn to page 49, paragraph 6 of the order. Having heard and counsel for the parties and considering the submissions made, it is found that on the ground of being overaged, petitioner's application when was not entertained by the board, pursuant to the advertise issued under Annexure 1, she approached the court in WPC number such and such. The writ petition was dismissed by the order dated 19/4/2021. After dismissal of the writ petition, petitioner made the application under Annexure 5, which was wrongly accepted. My lord, this my humble submission. This findings of the honorable single judge is not correct, my lord, because there is a provision in OCS upper age limit relaxation rules 1989. There, if they have not made the selection for so many years or earlier years, then the person who were eligible by that time, he is also eligible and he can apply against the backlog vacancies. This selection has not been made from 2016, and for the first time in 2021. I only 4 days old became overage by that time. Therefore, I made the application and they have accepted it. And merely because my earlier application was dismissed, the Honorable Court has rejected my application by saying that she should not have made the application earlier. The second aspect is earlier cause of action and present cause of action is different. That point of time, I came before this Honorable Court that they have not accepted my application. Once they have accepted my application, issued the admit card, I participated in the selection and provisional final list was published. Now, when they did not publish my final merit list, final select list, then I came. But in subsequent cause of action, I came before this Honorable Court with the plea that two grounds I have taken, that the upper age limit rules 1989, that I should have been considered because the vacancies, backlog vacancies were 972. Secondly, my lord, I have also taken the stand that since the corona period was there, that your lordship is aware that Honorable in so many cases has already said that 1 year period is to be grace period will be on 2 grounds. I came before this Honorable Court and that was outright rejected because earlier application is rejected. Therefore, I am before you.
Right. And give a glass to the advertisement. The advertisement and annexure 1. Page 21, the relevant portions. The age limit for general category shall be 21 years and minimum age shall be 42 years of age as on 1/1/2021. Now, this condition stipulated in the advertisement, in fact, never allowed the petitioner to offer his candidature. So that is why in the first round of litigation, he approached this honorable court. Now, this honorable court disposed of that petition with a specific finding that petitioner has already crossed the age limit of 47 years. So his application has been rightly not accepted by the authorities. Now that order has attained finality. That order was never questioned before any forum, nor the condition stipulated in the advertisement was ever challenged on the ground or the plea which is being taken now, that as per 89 rules, the had there been the recruitment, then I would have been eligible. And since there was no recruitment, so in terms of that rule, subsequently, because the condition stipulated in the advertisement was never checked, nor the order passed by this by the honorable single judge in first round of litigation was also never challenged. Now, for some reason, my lord, his application, he offered his candidature, and that was, I can say, mistakenly accepted by the authorities because that was given in online application. That was accepted. Now, even if it is accepted, then he has to be treated like any other candidate, those who have offered their candidature. Now, what is the condition stipulated, the other conditions stipulated in the advertisement, your lordship, may kindly see. The other conditions, that is at page 23. Page 23, your lordship, may kindly see. Admission to the written examination or viva voce test will be provisional if on verification at any stage before or after the written examination oblique viva voce test, it is found that a candidate does not fulfill the eligibility condition, which is the age here, his or her candidature will be liable for rejection. Decision of the selection board in this regard to the eligibility and otherwise of the candidate shall be final. This is the condition. Now, with eyes wide open, he has accepted this condition, even if I contend that his application has been wrongly accepted or it has been accepted. This advertisement, then next B, this advertisement should not be construed as binding on the authority to make recommendation for appointment. This is another condition. Then page 24. Mere F, my lord, F, mere empanelment in the select list shall not confer any right for appointment. Now, having accepted these conditions, even if his first, the order passed by the honorable court never challenged, the condition stipulated in the advertisement so far as age is concerned, that was never challenged. Now, even if considering the fact that his application was accepted, still then his case has to be considered in terms of the conditions stipulated in the advertisement. And with his eyes wide open, he has accepted these conditions. Now, at a belated stage, when it was found that he is overaged, it was not considered. So the authorities have rightly acted in terms of the conditions stipulated in the advertisement.
the short of unnecessary details. Pursuant to advertisement. Is by the Department of Higher Education. For recruitment to the post of a lecturer. Leadership. For the non-government aided colleges. In different subjects. Come on. The applicant initially attempted to offer his candidature. But because of the age restrictions. Such applications could not be uploaded in the official website. Stop. The applicant across this call. There is that I think the solution. Or a direction upon the authorities to accept the authorities to allow the applicant to sign the online application for the post of a lecturer within the post of in Sanskrit subject, and also to participate in the recruitment process. It would be opposite to quote the Lease claim in the said resolution. In extenso post is relevant. Well, from it appears that the week of age relaxation was specifically treated in paragraph 6 thereof. To the extent that the moment the law permits the relaxation of the age in respect of the candidates belonging to the reserved categories. There is no justification not relaxing the age part in respect of our ex-serviceman. It is further pleaded that the applicant being a woman candidate is entitled to get the relaxation of 5 years age for applying the clause under the above advertisements. In terms of the different in terms of the notifications and of the rules applicable in this. The said petition was disposed of on 2021. on the premise that once the outer limit is fixed in the advertisements, and admittedly the appellate having crossed the said outer cap is not entitled to seek a direction upon the authorities to permit her in uploading her application in response to the advertisement issued by the department for recruitment of the post, recruitment the post of an lecturer. Subsequently, the online application was accepted by the system, and it is undisputed that the petitioner was permitted to undergo the tiers of the recruitment process. And the name was also included in the provisional list published by the publisher. Subsequently, the petitioner was kept out of the zone of the appointment, as she was not included in the final list. The requisition came to be filed before this court, and the final order dated 14/11/2024 was there is a safe in yes. The council for the appellate also for us is subject that the civil bench ought not to have dismissed the requisition solely on the ground that the earlier requisition filed by the appellate was rejected and or dismissed. According to the council for the appellate, the cause of action accrued to the appellate in an earlier, at the time of filing of the earlier petition, is completely different to the cause of action which has arisen subsequent thereto, and therefore the rejection of an earlier petition cannot defeat the right claim in the subsequent petition. It is further suggested that there is no fetter on the part of the state to relax the outer cap in relation to age in the public employment, and the single bench did not consider the case in such perspective, but was totally swayed by the fact that the other petition filed by the petitioner having rejected, no further relief can be granted in the subsequent resolution. The government for the state opposes the submissions made by the council for the appellate for us. According to this, the earlier petition was dismissed with the categorical finding that the petitioner having crossed the outer age limit fixed in the said advertisement is not entitled to offer her candidature, which cannot be said to be infirm and unable. he further submits that mere acceptance of an application through an online mode does not confer any right into an employment, into an appointment, as the mistake does not confer an irreducible right into a candidate. The further submits that the applicant is also a stop from contending that once the application contending that the cause of action accrued to the applicant at the time of the first writ petition filed before this court and the second writ petition are different. As per the advocate for the state, the moment a categorical finding is returned by the writ court that the petitioner has crossed the outer age limit, such decision having not assailed before the higher court, attained finality and remained binding on the petitioner. Next one. On the prospectus of the aforesaid facts and the submissions so being, let us examine whether the judgment impugned in this case suffers by the vices of the illegality and of inequality, and the findings made by the second page are liable to be interfered with on the score of the submissions made by the applicant. That the advertisement issued by the government in relation to a public employment has not been challenged at any stage by the applicant. But in fact, the applicant intended to take the benefits of such advertisement by offering her candidature. And therefore, this court can certainly proceed to decide the points on the basis of the terms and conditions embodied in the said advertisement. It is beyond the level of dispute that the advertisement contains the outer age limit for the candidate to offer their candidatures for the post indicated there. And admittedly, it does not contain any stipulation conferring power upon the authority to relax any or more conditions incorporated there. The authority cannot act beyond the peripheral of the powers so conferred, nor can assume the powers not provided either in the advertisement or the rules which has a statutory flavor. The authorities have to travel within the circumference within the circumference of the terms and conditions and embodied in the state advertisement, unless the power can be traced from the statutory document. The moment the outer limit in relation to an age is fixed, as the power to relax the same is not provided, the authority cannot transgress the boundaries in absence of any express conferment of the powers. Apart from the same, in an earlier round of litigation, one of the issues involved therein was relatable to the power to relax the outer age limit fixed in the state advertisement. And while discussing the writ petition, the single bench made a categorical finding that in the event an outer age limit is provided, the appellant having admittedly crossed the same outer limit is not entitled to any relief claimed in the said writ petition. The moment the court observed that the petitioner, the appellant is not entitled to offer the candidature having crossed the upper age limit, it cannot take a rebound nor take advantage of the mistake committed by the authority in permitting the appellant to upload the setup. The mistake does not confer inchoate or irrefusable rights into a person. And before and the moment the authorities rectified the said mistake, such action cannot be impinged, as at one point of time the authorities permitted the petitioner to participate in the recruitment process. Furthermore, the court cannot issue a writ of mandamus upon the authorities to act contrary to law. Nor the judicial disciplines demand a departure from the earlier decision which attained finally. The principles of issue estoppel, akin to a res judicata, has its applicability. If the issue which was directly and substantially an issue in the earlier proceeding has been decided by a competent court, such issue cannot be re-agitated and or decided by a court in a subsequent The contention of the petitioner that the cause of action in the earlier writ petition and the cause of action in the subsequent writ petition are different is unacceptable for the reason that the real issue involved in the litigation is whether the petitioner who admittedly cross the outer age limit may be permitted to offer the candidature in pursuance of the said recruitment clause. Once the court has decided that the petitioner is not entitled to offer the candidature having crossed the outer age limit, even if in a subsequent writ petition, the challenge is thrown to the decision of the authority in not offering the appointment is in effect based upon a conscious decision that the petitioner was ineligible to offer her candidature having crossed the outer age limit. The genesis of the decision of the authority which has a direct impact. Now, the genesis of the authority is founded upon the factor of the age barrier, it becomes an issue directly and substantially in the subsequent writ petition. Our attention is also drawn to the several clauses of the advertisement, providing conveying the laudable message that mere participation or inclusion in the provincial list cannot be construed to have conferred any right to import appointment, and even at the time of an appointment, if the authority found that the candidate is not otherwise eligible, his candidature can be rejected. Since the terms and conditions embodied in the said advertisement is not a subject matter of challenge either of the litigation, the petitioners cannot come out of the legal thereof, and the action of the authorities cannot be said to be in flagrant violation of the aforesaid counsel. Lastly, a plea was taken that the rules framed by the state government permits the relaxation of the age in the event the recruitment process was kept in place for a considerable period of time. Is not applicable and come to the aid of the petitioner. The said plea was available to the petitioner at the time of filing the first writ petition, which resulted into a dismissal upon a categorical finding that the petitioner has crossed the outer limit. If the plea or if the point or a plea was available to the petitioner at the time of filing the first writ petition, and having not taken therein, the principles of res judicata can also be applied in such situation in view of explanation 4 to section 11 of the Code of Procedure. It expressly provides that the plea which ought to have been taken, having not taken in the earlier round of the litigation, shall be deemed to have been taken in a subsequent round of litigation. And therefore, the estoppel by issue would be attracted, which is a basic foundation of the principles of res judicata. Next one. From whatever angle we look at, does not find any infirmity or illegality to include charges rendered by the witness. The appeal stands merit. The scene is hereby dismissed. However, in the facts and circumstances, there shall be no other exception. 16.
Yes, while the petitioner was permitted to withdraw, the order revoking the order blacklisting the petition form has already been revoked, and he has already moved the authority for consequential review. That may be right.
Item number 17.
Sir, the first case, the opposition preferred by the state is state was opposite part number 1 in the petition.
You have also challenged.
Yes, opposite part number 2.
Same order.
Same order.
What order it is? Both of you are dissatisfied.
Like,
both of you are dissatisfied.
Because the very simple reason is that a third party carving out a remedy matter being an opposite party.
So when both of you are agreed, then let us set aside the whole order.
No, sir, no. That the private parties are there. That is against the private party. Sir.
That's the humor. Don't go by it.
Yes, that sounds too bad. That sounds true. My humble contention, so far as that the repetition, the writ appeal preferred by the government, appeal part number 1, well, there is a limitation.
There's a delay of there's a delay of 505 days,
But my case, my second item, that is filed in time. The most important is that, my lord, the content petition filed is listed tomorrow, is staring at us.
Where is the writ petitioner? Who has filed the content?
Content, my lord, the writ petitioner and the beneficiary under the writ petition. Two content petition.
Who are you?
Yes, I am the opposite part number 2, Valami. Opposite part number 2 to the writ petition, Valami, Water and Land Management.
Valami means?
Water and Land Management Research Institution.
So you are the instrumentalities of the state.
Yes, ma'am.
No different. And they are the state.
State.
One is an alter ego of. One is an alter ego of.
That's correct, ma'am. That's correct. That's correct. If I also, so far as the writ appeal is concerned, though there is a delay, both can pursue.
So notice on her section 5 is required. Sir.
My lord, this is last time private opposite parties were appearing.
No.
Then you give a notice because section 5 is that accrued a valuable right into a successful candidate. So without hearing, we can't allow.
Well, it's only point, my lords, in the case of.
Anybody who appeared before the single bench, can he accept the notice? So we can expedite it.
My lords, I have the instructions to appear.
On behalf of the writ petitioner,
I was one of the writ petitioners there before the honorable single judge.
one of the writ petitioner or the writ petitioner?
Like, my lords, in Soparaj, I was in WPC 753 of 2025.
That is not under charge.
Just a minute. 7525. I was one of the opposite parties. Here I am made respondent number 6. I'm told they should send me a copy, my lord, for that so that I can know. And so far the WPC 2955 of 2023, I am also respondent number 7 in that writ application. They should send me a copy so that I can go through that, I can place my matter, my lord, before any order is passed.
It's not WPC, my knowledge, the senior brother man is referring to WA.
WA. I'm sorry, I stand corrected. That is writ appeal. I stand corrected.
They were my lords. No, writ application, there were 3 petitions. 4 months, I think. Four petitions.
No, 6.
One is added. My lords, intervention applications were filed by the opposite party, 5 and 6, and
They intervened. They intervened, my lord.
intervention, they have been allowed.
Hello, that intervention. Yes, that is, they were the intervener.
So you'll have to serve the copy. Who are you? What's the name of your client, sir?
My client's name is Gitanjali Jagdev. Yes, my lord, and I have been made a party allowed by my
Gitanjali, yes, respondent number 7.
Yes, my lord. In one, in respondent number 7, in another writ appeal, respondent number 6.
But we have to issue notice of all. Yes, please, please, we issue notice of all.
Yes, my lord.
As so far as your appeal is concerned within time,
Yes.
when you serve in
I'm serving copy, my lord. Yes.
appeal or something, I do not know. We are, I am proved where we call it a memorandum of appeal.
Memorandum of
Ground for
Yes.
appeal.
Yes, my lord.
What is the memorandum?
Memorandum.
The application form. It should not contain any verification, it should not contain
Anything. So affidavit also.
no deposition, deponents.
Only sign of the signature.
Only the grounds, nothing more than that.
Yes, that is that.
The order 41 rule.
Yes, ma'am.
But here I find the.
My case, my lord, is memorandum of appeal I refer to. Second item. This is memorandum of appeal. I'm also, my lord, it's a civil side, it carries very important, my lord. That is memorandum of appeal. But affidavit, unless my lord, we give it,
You serve the.
I will serve the copy to my lawyer friend. But fact remains, my case is not my by limitation, but this is well in time.
What has been there?
Well, so that I will take 1 minute. Well, it's kind of class 2. That judgment impugned by us. That is at paragraph number. Paragraph 53, man. Running page 66, second item. Running page 66.
What, 50?
53, paragraph 53.
The first petition is on page 75, my lords.
I refer to my second item.
59.
Paragraph 50?
3. 53.
Next item, that's really. That's unique.
Principle of res judicata is applied.
Not applied.
Oh, in respect of our interlocutory order.
Not in respect of an interlocutory order, because that was a repetition filed and scandal got this done.
No, I'm sorry, I say that arrive at the incidental and ancillary issue.
Yes. That incidental, that observation was my humble submission, that is what we raise objection. So our submission would be that.
According to you, it was a direct and substantial issue.
Substantially is an issue. That is what I'm referring to. The opposite part number 6 and 7. Individually, they filed 2 writ petitions earlier. That writ petition bearing OJC number 4429 of 2002. No, that was disposed upon 10/8/2016. We give me a copy of that man. Okay, writ appeal dismissed for default. Thereafter, they got implemented as a party. Now, this particular judgment, where particular issue was also framed, whether that issue number 1, whether the Gopabandhu Ayurveda, the Gopabandhu English medium school is functioning in Valmiki campus. The Honorable Court come to a conclusion, no, and thereafter rejected this petition, against which they preferred appeal. My lords, appeal, I have given that copy of the appeal order, my lords. Review order rejected.
Then that was dismissed for default.
That was the appeal was dismissed for default. Review was dismissed on merit.
No, I understand.
Now, question is to be examined whether
between the same parties, then sir, how the res judicata will not apply?
Let them have the
Where is the concept of incidental and incidental issues?
Yes.
If the foundation is there, it does not mean like a civil proceedings that under order 14, the issues are to be framed by the court. No, the issues have to be deciphered from the perspective.
That is what so there's it's explanation 4.
Explanation 4 is a different.
No, but my humble contention is purely a case of where the section 11 is attracted.
Says that the plea which was available to a litigant, but he has not taken.
So here in this case, section 11 is itself attracted.
Explanation 8, my lord.
Section 6, explanation 6.
Explanation 6. Here in this case, section 11 is attracted.
What I respectfully submit, my lord.
Constructive res judicata.
Yes.
My lord, let them serve a copy on me, let it come tomorrow, we'll be able to satisfy. Let them serve a copy on us today.
Today
You have to bring 2 things. First is the earlier writ petition, arraying the parties,
right,
who were the parties,
right, man,
the instant writ petitions, who are the parties,
right, man,
and the judgment of the earlier writ petitions, where the issues have been set and decided finally. And the issue which is raised here. That's all. We do not want anything more. Let him come.
Yes, I will bring it. Can it be taken up next week any day, my mathematics?
Contempt is coming when?
Tomorrow, man.
So don't proceed with the contempt. Because we find if the contention appears to be correct, then in that way we have to. Your appeal number is
Well, it's 2955 of 2023, ma'am.
2955.
55. Second item.
Recorded organic decline from credit changes.
Okay.
After the running senior and big appeal for the appellate. Which that the London single that the London judge in the single bench have wrongly applied the principles of res judicata by creating an illusory distinction between an issue which is directly or substantially an issue in the proceeding and the issue which is ancillary and or incidental to the cause of action. According to him, in all the situations, once the issue is decided finally in an earlier round of litigation, the principles of res judicata would be attracted in a subsequent round of litigation. At this juncture, Mr. Roth, the learned senior advocate, appears and submits that he has instruction to appear on behalf of the respondent number 7.
6.
The sixth. And the copy may be served upon his advocate in record.
Yes, ma'am.
The Mr. Roth, the learned no. Mr. Roth, the learned senior advocate, for that the matter will be taken up on any other day.
Next week, I mean.
Provided the copy of the memorandum of appeal as well as the application filed in connection there. We served upon the advocate and record by tomorrow. So, Mr. Mohammed, the learned senior advocate, submits that taking advantage of the pendency of the instant appeal, the other side is proceeding with the contempt application filed before the single bench.
May I submit the number, man?
Which is likely to be listed tomorrow. So,
We'll take time in that case. I undertake to take time in that contempt petition.
So, considering the submissions advanced before us, let's list this matter in the next week, give a date.
3rd July.
Seventh? Seventh. We request the learned judge in the single plea adjourn the application for consideration. If listed above.
May I submit another thing, my lord? I could make, sir. There are two private opposite parties. My lord, senior brother.
We are the currently directed to serve the. I do not know the notices to be issued.
Issued in respect of opposite party number 5,
Can you appear, Mr. Ram?
Opposite party number
Who
5.
represented them in the single venue?
Yes. Case is fine. That is better. I will serve a
And
copy.
you know, you can take.
Yes, the accused case is fine.
Can wait the notice, can wait the notice.
Yes.
So that we can regularize.
Yes, so that matter can be had on that.
Yes, that is what we want to
Yes, yes,
regularize that.
We
Yes,
will
well,
understand.
notice and, some
Yes, I will serve a copy tomorrow.
record and appeal, that appears for.
Opposite party number 6. Is it
Now,
five?
who is left?
Opposite number 5.
Who is left?
Well, it's opposite petitioners, those who are the petitioner in the read petition, that is petition on opposite part number 1 to 4. They are the private parties.
Who will?
Mr. Rautra, earlier Mr. Rautra, senior advocate, was appearing. I don't know. I will request him if he.
My information is he is to appear also.
Then I will request him minus 12. I will request him. I will. I will do one thing, my lord. I will request him to so that he's.
I will express the views taken by my lord to Mr. Rauter and then serve a copy to Mr. Rauter.
Yes. Next. You issue notice on the, in our sheet.
Separate notice, notice to go in that
Notice on the
because there are
limitation.
about 600, 700 is
Yes.
related.
Why is it? Mr. Brother can receive that.
Notice on limitation.
Court separate now, notice to go, notice to go.
So far that first item is concerned. My knowledge
On the next.
is so far that first item is concerned. Submission mail, so far that item number 1, there is a limitation. State government before that appeal. Already the set of councils have appeared. Let them receive that copy from the government so that both can be heard together.
Let them separate.
That will go again on. Yes, big observation will help.
No, subject to approval of minus because we have to file objection in that case also because there is a limitation of 700 inch.
First, give them a notice, let us see what.
Yes, let them take notice.
Item number 18.
Please, Lord. The state has been taking time to file objection to my amendment petition, which is at flag C. We have not filed it till date. If your lordship may kindly allow the amendment, then I'll file a consolidated writ.
So we are in the. Why you do not want to oppose the amendment?
Let me.
So they have to, they have an additional right, even if it is allowed, they have to file an additional.
Yes.
No, Lord, one thing, let me just point out before your lordship. This is seriously affecting the home buyers. This is the pendency of this case. Lord, what the petitioner is essentially, this is in the nature of a PIL. So virtually the transfer, registration, everything of the apartments in the state has been staged. Registration, let me explain. But I do not know the petitioner.
Of the sale deed.
That's correct. How can that be state? Yes. Where state
On
is
what
losing
ground?
revenue, nothing. They are making some case. I do not know what is the basis of their argument. But let me be clear on one aspect. That in 2017, RERA was enacted. RERA is a self-contained code that takes care of everything. So that in the garb of a so-called pre-RERA period, we said that pre-RERA period, because RERA applies from a certain date in 2017. What is the effective date? Too effective, no. Essentially, that came into force from 1st of May 2017. The relevant provisions with regard to the formation of association,
etc., etc.
Registration and all of these.
So, Lord, we have directed by this government order that all pre-RERA sales, Lord, that would be registered. That home buyers have already invested substantial amount. Registration is not being done. Lord, in some events, some people also, those who are settling outside, they have not even sell their property for the lawful purposes, education of the children, health of the old parents. Somebody is migrating from Bhubaneswar to Delhi or outside. So this kind of, another batch of writ petitions were filed. The court directed that you make a law. That I do not know. So that was before the previous page. So anyway, they have come up with an apartment ownership act that is in conformity with RERA. And prior to RERA, there was a Development Authorities Act and also an Apartment Ownership Act. You will also know Section 11 recognizes the registration of apartment owners association under any of the existing laws. It may be a cooperative act or maybe a societies registration act or the apartment ownership act, any other prevailing law. So now they say that unless the occupancy certificate has been obtained by them, which was came only from 2015 by way of an amendment, those sales cannot take place. So that is affecting the larger public interest. So therefore, I pray this IA number 1960 of 2025, your Lordship may kindly have a at flag A, and interim order has been passed. That is disturbing a good lot of people, home buyers. They are in distress. They are in distress. One petitioner, I do not know what is his interest in this litigation. The entire registration process has been stopped to the detriment of the interest of a large number of home buyers and also the revenue. We are losing substantial revenue. State is losing for the last 7-8 years. There is no registration. At least from 2020, there is no registration.
What is the amendment you want to?
Yes, my lord. It's a frivolous case. They have been pursuing. I do not want to instead. We should the interest of large number of home buyers. Then it just
My lord, during the pendency of this writ petition and notification on 1st of February 2025 was issued by the state government, stating that the Act of 2023, an act which was enacted in the year 2023 and Section 2 whereof provides that this act will apply to all the apartments irrespective of the time when they are constructed. But by way of an executive instruction, they said that no, this act will apply only after 1/5/2017.
So
that has been stayed.
Operation of the act.
Operation of the notification has been stayed. Act is applicable, sale deeds are going on.
No, the act was enacted.
Yes.
Was it notified in the official gazette?
Yes.
Was it?
Yes.
How? Under what provision the act was enacted by the assembly?
It's a state act.
State act.
It's a state act.
If it is a state act, then there are two things. It receives either the consent of the governor or the consent of the president of India. How? Which consent was received?
The consent of the governor.
Or the president
of the governor.
Of the government. When this executive instruction was issued upon the concurrence of the governor or how?
The executive instruction was issued by the order of the governor, as it is written in that notification.
Correct.
So this honorable court, provided a detailed order on 12th of February 2025, held that this executive instruction is absolutely in teeth of the statutory mandate. Without amending the law by way of an executive instruction, you cannot simply nullify a statute which has been passed by the legislature.
That is not the case. It's quite
Then
misguiding.
let the state file the counter. They
No,
have
it's
not yet-
quite a misguiding.
My lord, they
state.
have not.
This kind of absolutely misguided.
What do you want to achieve?
I want to bring this notification on record in the writ petition.
These are all already there. Is the government notifications from the government's circular.
So my lord, then the writ petition can be heard if your lordship wants.
These are already.
Then it can be finally heard then. I'm ready with that. If your lordship is will take into notice this notification in final hearing, I am ready for it.
Let us assume in this regard. Let us see the impact of the Apartment Ownership Act.
Yes.
Let us see the impact of the RERA. how it works in tandem or one overrides the other and how it is to be done.
Yes.
Because I am quite conscious of certain provisions in the other state about the apartment ownership act.
Yes. Yes.
Let us see that it is similar or it is something which is.
Absolutely.
Show us the law.
My lord, if I have annexed the copy of the act at annexure 5, page 25 of the writ petition.
Yes.
Annexure 5, page 25. If, my lord, I'll take a 1 minute just to give a background of how this.
The time is there, it may take some time. Can it be taken up on 23rd minute? Sorry, 30th minute? Because it's 4:15, I have to address on this. 30th minute? Because it's already, your lordship may rise, 4:15.
Then my amendment may be allowed a substantive.
My amendment would be allowed. There's no correlation.
I will file my consolidated.
This particular petitioner, I have been watching since 2020. I do not know what is his interest.
This case has.
He may come with a specific grievance. In the garb of a PIL, he is turning the entire transaction, the entire infrastructure industry has suffered. Home buyers are suffering. Absolutely correct. I don't make an inquiry.
Anything, give me a broad fact.
So let us
consider.
Yes.
What is the broad?
My lord.
Broader aspect of it.
In the Odisha, there was an apartment ownership act in the year 1983, but that act never came into force like effect. It was defective. The forms were not there.
I am aware of the apartment ownership act of the another state where the government does not really put any mandate on the infrastructure project. Get them themselves registered under the apartment ownership.
Absolutely.
It was an option or the choice which was given to the respective the developers or the constructors to either get themselves registered or not. Similar option was also given to the respective associations. That's after handing over of the entire sale of the entire units. Or the apartments to the respective owners.
Yes, sir.
The maintenance and everything was given upon the association.
Yes.
Is correct that the association will be in different forms.
Yes.
One is under the Society Registration Act.
Yes.
They got themselves registered.
Yes.
Cooperative, I have a doubt.
No.
Whether it can be done. I have a strongest of doubts.
Exactly. It cannot.
Because it must have the initial genesis, otherwise it cannot be done.
Yes.
Anyhow, we don't say, or there can be a general incorporation of the companies. Under the Companies Act also certain associations
can be
of person AOP, they can be registered. So this is the choice which is given to them. I do not know what is the impact of this act which has come here.
In Odisha, we had a special law, that is the Odisha Apartment Ownership Act.
There also is a West Bengal Apartment Ownership
Act. We had it since 1982, but that remained unworkable. Not a single association could be formed under that act. Now, my lord, in the year 2000.
Again, I say it's a mandate or it's not a mandate. If it is an imperative under the act that one has to get himself registered, otherwise not, then in that event, I just wanted to know.
Yes.
There is an option.
I'm coming to that. Now, in the year 2017, the Real Estate Regulation Act came into force by the central government.
Prospective in nature.
Prospective in nature, and it provides that the projects which are ongoing to that it will
option.
Yes.
They can or they may not.
Yes.
Then
therein, Section 17 provided that at the time of sale of a unit, the common area, the land, has to be mandatorily registered in favor of the association. Without that sale being done, the unit cannot be transferred to the flat owner.
What?
Section 17 of the RERA Act.
What?
My lord, kindly. Yes. Yes. About section 17.
Transfer of tax.
Right. The promoter shall execute a registered conveyance deed in favor of the allottee along with the undivided proportionate title in the common area to the association of the allottee or the competent authority as the case may be, and hand over physical possession of the plot, apartment, or the building as the case may be to the allottees and the common area to the association of the allottees or the competent authority as the case may be in a real estate project.
What does it mean? Read it.
Yes.
I was really surprised that the developer or the promoter is bound to execute the deed of sale in favor of the association first, and then the association will execute the deed of title in favor of the respective allottees.
No, your lordship.
I was surprised with this.
No, that is not my submission.
It says, what it says is.
Exactly, that is part being submitted and the court was misled.
Execute the deed of
Changing its name.
allottees of the this one.
Yes.
And the common area.
Yes.
Which would remain as an undivided one because it cannot be. It has to go to an association.
Association of allottees.
Correct. So
Absolutely.
association of allottees means they will use and occupy and enjoy the common areas facilities.
Yes, your
Common with all.
Yes, your lordship. Exactly, your lordship.
So that is what.
Yes.
So where is the problem?
So in Odisha, we were not able to form the association of allottees.
Why it is necessary? It is what the owners of the allottee who will decide to form the association.
Because my lord, the common areas, then it was not being
It
transferred
will
the
go to
association.
respective allottees, it will say,
No,
it will go to the respective allottees.
my lord, that is why we filed a writ petition, a PIL before this PIL, before the Honorable Court. And this Honorable Court held that no sale deeds contrary to section 17 of the RERA
There
Act.
is no contemplation of the sale deed to be executed in favor of the association of persons. It is a farcical approach if one can make it. And being a student of a civil law, I am really.
Absolutely. That is what.
How the title passes in respect of my immune properties. Does it pass to a person who has not paid a single consideration? Money under the Transfer of Property Act, the sale can only be effected in respect of a immune property by executing a deed on consideration.
Yes, your lord.
And the association of person will not give any consideration.
The association consists of the
So
allottees.
that is why it says that they cannot keep undivided areas within their domain or the clutches.
The builder
It
cannot
has
keep
to
it
pass
within.
on to the association of
Yes.
persons so that the association will take care of its maintenance.
Yes, your lordship.
But the deed cannot be said to be infirm or cannot be executed unless the common areas is transferred.
Yes, your
The
lordship.
deed will stipulate
Yes, your
that
lordship.
this what should be the common areas. As I have come across at least thousands of the deeds
Exactly, your lordship.
where the schedules contained in the deed are divided. What schedule is in respect of the whole of the properties. The second schedule goes to a respective allotments, means the units or the flats. And the third schedule goes to the common areas which will remain common amongst all the unit holders.
That will go to the association.
Absolutely.
Yes, your
It
lordship.
will be commonly enjoyed by all the unit holders.
Yes,
That
your
is what it talks about the association of persons.
Yes, your lordship. So upon this,
This is not.
upon this, your lordship, my lord, the stay has not been granted on that aspect, your lordship. If I may just bring the background of this case, your lordship, in the previous PIL, the state contended that we are going to bring out a new law which will be RERA compliant, a new Apartment Ownership Act. And this Honorable Court recorded the state submission. And against that, an SLP was filed before the Honorable Supreme
I will
Court.
use that. There also what has happened. The RERA was enacted and immediately the state in exercise of that particular state based in schedule enacted a separate law which is called a HIRA.
Hira.
They call it a HIRA. And this was challenged, the Whiteys was challenged before the court and ultimately it went to the Supreme Court struck down.
Yes, your lord.
That once the central government,
Yes.
by virtue of their powers, have enacted a particular law,
Yes.
then it takes away or abuses the powers of the state to enact the same law.
Yes.
Contrary. So that was struck down. Now the RERA is made applicable pan-India.
Yes.
Every state, they are bound by the RERA. It's a central legislation.
Yes.
And under the concurrent list
Yes, your lord.
of the second schedule.
Exactly, your lord.
So in that event, there's no difficulty. They can't make the law.
Yes.
It's quite clear. There cannot be any second doubts on that.
Absolutely, your lord.
So what is the difficulty?
So now your lordship may come to
There's no implementation.
Yes. So that is being
Now,
implemented.
question is that when you talk about the apartment, the RERA comes in what way? The RERA comes that it is a beneficial piece of legislation to give a proper succor or the safety to the
home buyers.
the buyers
Yes,
of the respective units because of the urbanization and the exodus from a rural area to a urban area. There has been a lot of, I would say the exile or an exodus which has taken place. Shortage of infrastructure or the facilities to live in the urban area is a big issue.
Right.
And that gives a boon to some of the unscrupulous developers or the promoters.
Right.
And to regulate that, this particular act of RERA was introduced.
Yes, absolutely.
To take care of their.
My lord.
I think I've taken a good academic class.
Absolutely.
Quite enlightening,
This
your lord.
class was needed to be taken earlier. I'm sorry, my lord.
But
He has
these
not
sorts
been
of
taught
comments are not are
No, no,
completely
very
unwarranted.
apt comments.
It's a humor. You
That's
should
very-
embrace.
No,
Not-
Humor.
before your lordship's predecessors also these types of comments kept coming.
Yes.
And the matter also went to the
As a
Supreme Court.
lawyer,
Yes.
you should restrict to your.
Yes, absolutely.
Don't-
The state has approved the Honorable Supreme Court where their plea has been struck down. The Honorable Supreme Court held that unless the law is brought, nothing is going, no sale deeds, nothing. So now your lord,
So Supreme Court says no seal deed can be executed.
the order of this Honorable Court was affirmed by the Honorable Supreme Court.
By dismissal of the SLP
It was a
simplicity or
speaking order saying that what the Honorable High Court has held, it is correct.
show us.
My lord. My lord may see what the High Court held, that your lordship's order is at Annexure 3, page 20.
No, this order is passed in the instant writ petition.
No, in the previous writ petition,
Previous
Another
writ
not
petition.
yes.
I was just giving a background. Yes,
Where is that order?
my lord. At
Annexure?
Annexure 3, page 20. My lord, it starts from page 22. The learned, your lordship has it.
আইন করিব କିଛି ବୁଝିଲେ ଆଇନଟାକୁ ମୁଁ ନିଖିଲ କରେଇ ଦଉଛି ଗଲା ସେ କହୁଛି ନିଖିଲ କରିବ ସେ ପଡିବ କିଛି ଦରକାର ନଥିଲା
Yes.
My lord may see para 9.
No, I have already read the
Yes.
whole of it.
Yes. So against this, the SLP was filed. That is at next page, at page 23, the order of the Honorable Supreme Court.
Next page means
Page 23, your lordship.
the leave was granted.
My lord,
Special leave.
for
Leave was
permission,
granted.
leave was granted. The first paragraph is important.
Yes, I have seen.
My lord.
No, again,
So after this new enactment came.
that's the interim order.
Yes. So my lord may see the new act at page 25. Now, what is the problem which is happening now? This act of 2023 was enacted by the previous government.
Right.
My lord may kindly come to section 2. What was the legislative mandate of the state government? My lord, it says that the provision of this act shall apply to all apartments or buildings converted into apartments irrespective of whether the construction made before
or after the date of commencement of this act on a freehold land or on a leasehold land if the lease for such land is for a period of 30 years or more, including the sublease. My lord, the intention of the state government legislative mandate is that this act will apply to all apartments, irrespective of whether they have been constructed at what period of time.
Any building, even a one-storage building or a two-storage building will be apartment.
No, my lord, then the apartment has been defined.
Defined, I have fine, there is nothing which says about it.
My lord, apartment has been defined in section 3B.
I know 3B, after reading that means it does not create any distinction.
My lord.
Even a ground floor or a first floor can be regarded as an apartment. This is the building.
My lord.
Consisting of only 2 floors will be regarded as an apartment.
That is the act which
there should be a height. It talks about the height, that beyond this height, it will not come under the purview of the apartment.
It is where there are 7 units or more, generally they come into apartments.
No, it's the height. If it exceeds such and such meter, then it will come within the apartment.
Under RERA Act, it says that if there are more than 8 flats in a building, then it will apply. So, your lordship, now the important section is section 8. How the sale deeds will be registered, that process was enunciated there. Section 8 of this act. Section 8,
yes,
my lord. The deed, subsection 1. The deed of transfer of apartment shall be executed by the promoter in the name of the allottee or transferee, along with undivided proportionate title in the common areas to the association of allottees, in such manner and with such particulars as may be prescribed within 3 months from the date of issuance of occupancy certificate, and shall be registered under the provisions of the Registration Act. My lord, subsection 2, that is important. While registering the deed of transfer as mentioned in subsection 1, the promoter shall attach the following documents, namely the occupancy certificate, second, the ORERA certificate wherever applicable. My lord, 3, registration of apartment owners or allottees association certificate, if any. Registered declaration and amendment thereto. So, your lordship, the occupancy certificate and this apartment ownership certificate, the association certificate, these are mandatory requirements for the sale.
These are mandatory requirements because the act, while enacting it, indicates its date of its operation. So it becomes a prospective application. It has a prospective in nature, not a retrospective in nature. Because in the first section, that's why I was really wondering when I asked this question. Subsection 3 of section 1 says, it shall be deemed to have come in force on 28th the day of June 2023. So anything which is done after 28th of June. Normally when an act is notified, it says that it will be deemed to have commenced on a date as may be notified by an official, by way of publication in the official gazette. Then the moment the official gazette it is published, then it comes into the force. Here they have indicated the date. That means it's a more prospective in nature than to hover around the existing or the retrospective in nature.
My lord, actually, if I may just clarify a point, it's a repealing statute. The 1982 Act.
If you look at any act, even a RERA, if you come,
yes, sir,
you will find the subsection
on such date as may be notified by the
subsection 3.
Yes.
See, it shall come into force on such date as the central government may by notification in the official gazette appoint. Correct. That is what I say.
Even RERA Act has retroactive operation to buildings which are ongoing.
Now there is a distinction between a retrospective operation and retroactive operation.
Yes, absolutely.
When you talk about the retroactive, then you'll have to say that how it is retroactive and why it is not retrospective.
It affects some of the past transactions also which are ongoing. That is retroactive, your lordship. Hello, the judgment.
I am giving you the retroactiveness has been first recognized in the judicial parlance by our country in Mithilesh Kumari's case under the Benami transaction and prohibition. It says it's not a retrospective in operation, but the retroactive in operation. And the distinction is made that what is meant by retroactive and meant by the retrospective. Retrospective does not have any anterior date to operate.
Yes.
Retroactive will have a particular anterior date from which it will operate. That's the broader distinction.
Right.
So here, if it is retrospective, then it will all the pending transactions that would be.
Even the state contents, it is retrospective. That is what my case. The imbue notification, state says this act will apply from 1/5/2017. That is the state.
That is the state.
No, the notification, which I want to.
I just wanted to know. You are not challenging.
No, we are supporting this statute. Yes, we are supporting it, but the notification which is in teeth of this legislative mandate, that we are challenging here.
I'm having a lot of surprises with several provisions, so that's why I'm saying.
The state contains that this act will apply from 25th of February 2017. Now, from where did they get this date, a hypothetical date?
It can't be.
It doesn't say Mila.
Yes.
Quite incorrect statement. Sorry.
If the statute says that it will operate from a particular.
Yes.
Cannot be given from a retrospective.
The act itself says it is from June 2023 is submitting. What does this say?
The common principles which are applicable, every act will have a prospective operation unless intended by a legislation, by necessary implication or expressly to operate retrospectively.
Section 38 of the Act says that this act has been enacted by repealing an act of 1982.
Sir, that does not mean. That does not mean. Then what about section 6 of the General Clauses Act? About the repeal and saving clause. That whatever action which has already been done, whatever the things which have been taken, any proceedings which have been initiated will continue as if the repeal act is still in force.
Exactly. So there is nothing new imposition which this act brought into force. It just simply streamlined the earlier things.
Anyhow, I cannot express my mind. It is still open.
My lord,
but still we have a lot of dissent on a proposition of law.
I will completely explain.
Come with the judgments.
Sure, absolutely, Your Lord.
Absolutely. I will also make a homework.
Absolutely.
Let's 1 minute. I know your time, time has already been to rise. Let this. There is an embargo. Not to register. Since 2020, there is no registration.
You have seen there is a Supreme Court, the SLP was admitted, and thereafter the SLP was disposed of. Now we have to see the implication of that order because of that
Puneha Mamad. Pune Distillery and Puneha Mamad.
Volume 6.
Absolutely. Principle of merger. Your RCP is correct, but that is not the issue here. No, that is not
the matter. Is an interesting point.
Yes, absolutely. Very interesting point, Your Lord.
And more particularly on Saturday, there will not be any.
Yes, absolutely. I'm fine with it.
Saturday, this Saturday, tomorrow.
Any Saturday.
Any Saturday.
Yes.
What? Saturday.
If you are to inconvenience, we are not just saying that since it requires a very extensive hearing.
No, for your lordship, it may not even take half an hour. That is not the issue, but Saturday,
When we can. When we can.
In the first week of July, any day,
When.
my learned advocate general say.
we don't know any day, your lordship may take it up in the first week of July, correct?
When?
But that is convenient to your lordship. I'm there. Next week I'm there.
The next week it starts on 30th.
30th.
30th first.
Your lordship may take it up second. 2nd July, Virat?
Saturdays are all holidays, my lord. 26th only.
Any date convenient to your lordship may be fixed. We don't have any issues.
What?
First July.
My lord.
My lord, fixing it to second, my lord?
First.
First, wait, deeply of that.
Tomorrow,